father passed away this week, and I'm sure you'd want to join with me by extending individual and the collective sympathies of this committee to John and his family at this time. So if you're minded, we will communicate with them via the clerk in terms of passing on our condolences and thoughts at this time. Thank you, members. Okay, just going to advise those that have entered that they're welcome to use any mobile devices as long as they're in airplane mode and that all devices are muted, and it's not permitted to take photographs or record any part of the meeting. Are there any apologies, Clerk? I think we do have from Michelle and Anya.
Michelle, Anya Murphy's from America.
Okay.
Yeah. Mm-hmm.
And obviously John's,
and John, yeah.
Because of the family bereavement. Okay. And we have Aoife joining us via Zoom. Thank you, Aoife. Okay, I would remind you of your responsibility to declare any interest in any of the items under discussion today. Do any members have any interest to declare in relation to any of today's business? Okay, thank you, members. I'm going to move on to Chairperson's business. So regarding a visit to Tyrone Fermanagh last week, I would like to put on record my thanks to the committee team for the organisation of such an informative programme, which took us on Wednesday the 11th to visiting the Peat Bogs Restored and Unrestored in Tyrone, the Ulster Wildlife, then on to Lough Erne itself with the Deer Fisheries officials and RSPB, and then on to NSERC on Thursday after our committee meeting in Castle Archdale. And then where NSERC showcased its circular economy model of glass bottle production. Guys, if you're feeling a bit overheated in this committee room now, which is possibly likely, spare a thought for those employees that we met last week who operate the furnaces at NSERC. It was something to behold. Have members any comments that they want to make in regard to the visit?
Yeah, just general comment. It was extremely informative, broad-ranging visit, including the visit to Enniskillen as well, and just reiterate our thanks to for those who hosted us, and thanks to Janice and the team for organising as well. It was very well executed, I have to say, so thank you. Yeah,
I totally agree. Thank you very much for that. Thank you, members. Chairperson's business, item number 2, referred to pages 7 to 9 of the pack for the correspondence from Renewable RNI, dated the 10th of June regarding a request to brief the committee on the next steps in permitting renewable development on Forest Service land. A copy of their policy paper can be found page 10 of the pack. RNI represents a large majority of the renewable electricity industry in Northern Ireland. It believes that opening state forestry areas for renewable energy development could make a significant contribution towards meeting Northern Ireland's climate targets. Have you any comments to make, members, or and do you wish to invite RNI to brief the committee after recess? And if so, would it be useful if the briefing included an invitation to the Committee for Infrastructure to join that session?
Yeah, I think it would be an idea to get a briefing from our RNA. I think it would be helpful.
Yeah. So we put that on for after recess, guys. But do you think do you want one for ourselves, or do you want to extend the invitation out to Infrastructure? Do you think, because it's one of those cross-cutting, obviously. The climate stuff falls under the DERA, but also the energy. Well, energy sort of probably fits under the economy as well. Yeah. So you return to that because economy might be the better fit there, possibly. Yeah.
Yeah.
Okay. Thank you, members. Item number 3 referred to pages 13 to 33 of the pack to the raised paper we commissioned following the briefing from Aquaculture ANI. And that's the Aquaculture Overview of UK and Ireland. The paper provides an overview of the scale of the aquaculture industry and support provided to the sector across the UK and Ireland. Due to the volume of business on the agenda today, I propose we consider scheduling a briefing on the matter after recess when we will have more time to consider it. Members agreed? Thank you, members. Members, the Department has requested a copy of the committee's recent letter to Farmers for Action. After we had taken our legal advice, there's also a copy of the Windsor Framework Democratic Scrutiny Committee's correspondence regarding the proposed EU regulation and strengthening the position of farmers in the food supply chain that we considered at the 5th of June meeting. Are you content to share those letters? Thank you, members. Item number 5, I refer you to page 3 of the table papers to correspondence from the Minister dated 17th of June regarding the consultation of Marine Strategy Part 1, the UK Updated Assessment and Good Environmental Status, which is due to launch on the 20th of June for a period of 8 weeks. Members, I also refer you to the consultation document and the summary of progress toward good environmental status starting at page 4 of the table papers. Following the period of consultation and review of responses received, the Department will provide a briefing to the committee. Any comments, or are you content to note? Thank you, members. Item number 6, referred to page 90 of the table of papers, the correspondence from the Minister dated 17th of June regarding the publication yesterday of the interim report of the Independent Review of Environmental Governance in Northern Ireland. A copy of the correspondence was circulated to members by email earlier this week. A copy of the interim report starts at page 91 of the table of papers, and the final report is due during the summer period. Do you have any comments you can tend to note? Thank you, members. Item number 7, referred to page 152 of the table of papers, to an invitation to the Aberdeen Angus Cattle Society's 150th Herd Book celebration, hosted by the Doyle family, Drumhill Herd in Cookstown. The event will be held on Tuesday the 24th of June, and it starts at 4 p.m. On behalf of myself, now not on behalf of the committee, I did respond to the invitation just to say that it's a plenary day, and depending on plenary time, it may or may not be possible for members to attend, but obviously that's for yourselves to consider. Okay, agenda item 4 is minutes of the meeting on the 12th of June, referred to pages 35 to 46 of the pack for the draft minutes from our meeting dated the 12th of June. Have you any comments? Are you content that the minutes are drafted? And if so, I will then sign them, and these will be published on the website. Thank you, members. Matters arising, agenda item 5. Item number 1, referred to page 48, 49 of the pack, to the response from Solace and I dated the 10th of June regarding the Northern Ireland Shows Association. As you will recall, we received a further briefing from NISA at our meeting on the 1st of May and wrote to Solace to encourage financial support from councils to NISA's programmes of work. The response states that councils operate as independent organisations, and the level of support provided to all voluntary sector organisations is agreed by each council individually. Solace and I state that they encourage NISA to continue engaging with each of the 11 councils regarding support required to deliver its future programmes. Have you any comments? Are you content to note? Are you content that we share that piece of correspondence with NISA? Yep. Thank you, members. Item number 2, refer you to page 50 to 51 of the pack, the response from the Department dated 10th of June regarding the ongoing odour concerns at Cabra. I also refer you to page 52 to 65 of the pack, to the copy of the NIEI Odour Impact Assessment Guidance for permitted and licensed sites. As you will recall, on the 22nd of May, we considered the Department's previous response and requested information regarding the method used to measure and analyse the odours. The response states that odour pollution is to be perceived by an authorised officer of the department, meaning that an NIEI officer must personally detect the odour using the FIDOR methodology, which includes frequency of detection, intensity as perceived, duration of exposure, offensiveness and receptor sensitivity. NIEA Odour Impact Assessment Guidance for Permitted and Licensed Sites, August 2012, members, is attached for further information how the NIEA office conducts what are sniff tests, really, as I see it. The guidance states that a low analytical and dynamic olfactometry can be used to assess odour. The guidance concentrates on undertaking a simple sniff test. I did raise this at the time, guys, because I had hoped that odour detection was not down to one individual undertaking a sniff test, albeit with various rules and locations the official must abide by doing the test. So I know it's sort of stipulated and written down, but I think that the response begs the question why the sniff test is used rather than the analytical and dynamic olfactometry measurements referred to. So I'm going to propose that we write back querying why other methods are not used. The guidance that they are using is dated to 2012, and I imagine that technology has moved on since then. I'm just going to ask also, do you wish for RAISE to look into the available methods used elsewhere? And have any of you guys got any comments? I know that some of you guys are particularly affected because they're constituency issues. Declan?
Yeah, I think we definitely need to explore this further, because if you're doing a sniff test, I drove past it this morning and I could smell it myself. Yeah. You know, so and I'm sure if you have been listening to radio during the week, there was representatives of the community association and the local football club there who have been given their experiences of it, of children actually being physically sick because of the smell, and training having to be cancelled and called off. So that this is having a serious impact on that community. So I do think we need to do what we can to apply whatever pressure we need to do to get this matter resolved.
Yeah, so and this is not to be alarmist, and genuinely is not to be alarmist in any way, but I think the nauseousness of any odour is absolutely of concern. But I think what people also want is that they understand that the air quality is maintained. So that there's the health aspect which people need certainty around too, and that's why I think it needs to be more than. I think we should certainly investigate that we can do more than a sniff test. Patsy?
Your process is one thing. What I would like to know is, like Declan, because we've heard the public outcry about the smells around this place. I'd like to know how many times NIEA have been out to the site, for how long, and on what dates and times of the day. I think that would be important to help reassure the local public that in fact they are taking a very active interest in this, because this has been going on quite a while, and it has received quite a bit of public outcry around it in the local community.
Well, 100%.
And I would support Declan in that, because we need to be reassured that in fact NIEA are carrying out their with the full rigours, their duties.
100%, totally agree. So we're going to ask Raise to investigate potential solutions and other methodologies of use. We're going to investigate when, how often, when, and durations and the times of the day that NIE have on record as having attended. And also, in terms of that, it's, for me, it's not just simply the odour, because an odour has something in it. You know, that there's the process, and that certainty that there's no issues with the public health as well as the nuisance of the noxious nature. Is that okay?
I think if you wouldn't mind, in their correspondence, just to highlight to NIA that this is a constant and ongoing issue in that community, and it's affecting the immunity and the quality of life of people. And if you heard the health and wellbeing coach from that local club speaking the other day about the impacts having on children who are actually physically sick, vomiting because of the smell, I think this is something that we really need to, whatever influence we might be able to bring to bear on NIA and the department to, execute their full powers to try and get this resolved.
Chair, sorry, on the wider issue, we have had correspondence over the last 6-7 months from different sites and different individuals, referring to different sites. And there's another letter.
There's another one today
yeah.
from another site, and I'm very close to was the Mull of Glass. If you remember, there was quite a bit of traction in the chamber last time round about the odours from Mull of Glass landfill. So very, very aware of it. Okay, thank you. Members, okay. Okay, item number 3 then. We're going to refer you to page 67, 68 of the pack, the response from the department dated the 10th of June on the OEP water quality report on unprotected sites. As you recall, at our meeting on the 29th of May, we had a briefing from the OEP and then wrote to the department on how it is handling high risk and very high risk new and emerging pollutants. The response states that DARE will engage with the UK Technical Advisory Group to create a new system to replace the former EU watch list mechanism and for setting environmental quality standards within Northern Ireland. We also asked how many protected sites are publicly owned or under the management of the public sector. The response states that there are 394 areas of special scientific interest in Northern Ireland. 28, 71.1% have outright public ownership management, 140, 35.5% of shared ownership management between public and private owners, and 227, 57.4% are completely privately owned. In terms of area, 24% of the total hectareage is under public sector ownership. Are there any comments you can tend to note at this stage? Thank you, members. Item number 4, referred to pages 71 to 72 of the pack, to the response from the department dated the 10th of June regarding the farm sustainability standards and penalty matrix. You will recall at our meeting on the 22nd of May, we queried why the department will be laying the SR via the negative resolution process rather than by affirmative resolution. The response states that the Agriculture Act 2020 set out the provisions relating to the modification of assimilated direct law relating to the former CAP regime in Northern Ireland, and provides that there may by regulation modify, amongst others, horizontal regulation EU number 1306/2013, subject to negative resolution. So regulations would be subject to affirmative resolution only if it required amendment to the regulation EU number 1305/2023 or 2013 or 1307/2013, which in this case it does not. Have any members got any further comments? Are you content to note that correspondence and clarity? Thank you, members. Okay, we're now moving on to agenda item 6, which is the briefing from the department on the legislative consent motion on animal welfare, import of dogs, cats and ferrets. So, members, the legislative consent memorandum on animal welfare starts at page 74 of your pack. We have the Animal Welfare Bill and explanatory notes starting at page 79 of the pack, which is clauses 1, 2, 3, 4 and 8 within the bill to extend to Northern Ireland and require the Assembly's legislative consent, and a copy of the Department's rationale we considered last week for requesting an expedited reporting period at page 105 of the pack. So at our meeting last week, we agreed to write out to the following stakeholders seeking their views by noon on Monday the 23rd of June on the bill as part of our scrutiny on the LCM. Those were the Kennel Club, Dogs Trust, Cats Protection League, USPCA, Solace and Northern Ireland Local Government Association and a Ferret Rescue Centre. To this point, we haven't had any responses, but I'm now going to welcome the officials to the meeting via Zoom and invite them to brief the committee. We have Christopher Andrews, the Deputy Director of Animal Health and Welfare Policy, and Darren Fullerton, the Head of Livestock Identification and Germinal Products Policy. So, gentlemen, please feel free to brief the committee. Thank you for your time this morning.
No problem. Can everybody hear me okay?
Yep, that's good. Christopher, thank you.
Perfect. Okay, first let's just give the members a little bit of background on the bill. So this piece of legislation was introduced to the House of Commons in October 2024 as a private member's bill by Danny Chambers MP. The bill passed a second reading in November 2024, and at that juncture, the UK government decided to confirm its support for the bill. In February 2025, Barnes Hayman, the DEFRA Minister with responsibility for animal welfare, wrote to Minister Muir to ask if he wished to initiate the legislative consent process. And in March 2025, Minister Muir said he did wish to initiate that process, but this support was subject to the necessary approvals being obtained in the executive, as well as obtaining the views of this committee. In terms of the bill itself, it is quite short. It contains 8 clauses, 5 of which apply to Northern Ireland. It covers 2 topics. The first is the non-commercial movement of cats, dogs and ferrets between Great Britain and countries beyond the United Kingdom. And the second area is the welfare of dogs, cats and ferrets, which are brought into any part of the UK, including Northern Ireland, from countries beyond the UK. Only the welfare element of this bill will apply to Northern Ireland, but I will cover both elements of the bill in this particular briefing. So I'll firstly deal with the non-commercial movement of animals into GB. This bill will amend assimilated European law on the non-commercial movement of pet animals, colloquially referred to as the Pet Travel Regulation. It will enable England, Scotland and Wales to reduce the number of personally owned dogs and cats that can enter Great Britain from countries outside of the UK from 5 to 3. It would also contain an enabling power to permit England, Scotland and Wales to make regulations that would restrict the importation of cats and dogs which are below the age of 6 months or more than 42 days pregnant. This element of the bill will not apply to Northern Ireland, as the EU Pets Regulation continues to apply in Northern Ireland and is contained within Annex 2 of the Windsor Framework. That said, I would like to highlight that these amendments, particularly the proposal to restrict non-commercial imports of dogs and cats from 5 to 3, is to enable DEFRA to deal with specific patterns of puppy smuggling which occur at channel ports in England. The explanatory notes of the bill set out the particular challenges faced by those channel ports. And the situation arises whereby traffickers routinely try to bypass import rules at those channel ports by presenting consignments of low welfare pups as their own personal animals in batches of 5. Traffickers also using the channel ports have sought to circumvent puppy smuggling initiatives by bringing in pregnant dogs to the UK, again under the pretense that the dog is a personal pet. I wish to assure the committee that these are not scenarios that we realistically encounter in Northern Ireland. Rather sadly, evidence shows that Northern Ireland has been a conduit and a transport route for low welfare pups, which are then taken from here to Great Britain via our ferry ports to be placed on the market by unscrupulous sellers. In terms of the provisions that do apply to Northern Ireland and the provisions which we are seeking the consent of the Assembly, the bill will confer a power on all relevant national authorities in the UK to make regulations in their respective legislators on importing cats, dogs or ferrets, which promotes the welfare of those animals. In the case of Northern Ireland, the national authority will be the department, and the provision is a quite wide-ranging power, and it was expected that we would use it to make secondary legislation to prohibit the direct importation of cats and dogs which have been mutilated. And by that I mean dogs which have had their ears cropped purely for cosmetic reasons, or cats which have been declawed. The bill will also enable the relevant national authorities to outline the extent of the provisions that should be contained in any secondary legislation. Therefore, regulations could include the ability to enable cats and dogs to be exempted from certain provisions where an application has been made and a permit has been issued, the right to require records from individuals, the right of entry and the right to inspect, seize, search and detain, and powers to detain an animal where that animal is proven or suspected of being illegally imported. The bill, as you would expect, also includes powers to establish criminal offences, and these offences, if prosecuted, could be heard in either a magistrate's or a Crown Court. Sanctions and penalties would range from a fine, a custodial sentence, or both, and the maximum penalty that would apply if an offence is sent to Crown Court is imprisonment for a term not exceeding 5 years, or a fine, or both. These penalties all mirror the penalties available under the 2011 Welfare of Animals Act. Indeed, it's also already illegal under Section 5 of the Welfare of Animals Act to carry out a procedure which interferes with the bone structure or sensitive tissue of an animal. This makes it an offence to crop the ears of dogs and declaw cats, but only where that action takes place in Northern Ireland. It is also an offence to take an animal outside of Northern Ireland and have these procedures performed elsewhere before subsequently bringing this animal back to Northern Ireland. Therefore, gaining these powers to ban the imports of dogs and cats with mutilations could close off legal loopholes around ear cropping or other mutilations where people buy those animals directly. Members will also be aware that the Irish government banned the imports of dogs with cropped ears in September 2023. Therefore, we would see this bill as presenting an opportunity to establish parity across the island of Ireland. In terms of consultation, no part of the UK is formally consulted on the contents of this PMB, nor is consultation necessary at this stage. The purpose of the LCM is to provide powers to implement restrictions at a later date by way of secondary legislation. Therefore, any legislation brought forward would be subject to the full scrutiny of the Assembly, and this policy proposal would be subject to public consultation in Northern Ireland. I can also assure members that in accordance with the duty under Section 75 of the Northern Ireland Act, the Department has undertaken all the necessary equality screenings, and it is the Department's assessment that there are no equality, human rights or good relations issues associated with the provisions in this bill. Likewise, a rural needs impact assessment has confirmed that there will be no differential impacts. So to conclude, I want to stress that the bill would not make any immediate changes to the law here when it receives royal assent. Rather, the Department would use the powers contained within the bill to bring forward legislation to this Assembly with the aim of complementing existing animal welfare legislation. The end goal is to provide secondary legislation which safeguards dogs, cats and ferrets and stops people from owning personal pets which have been subject to painful mutilations. So happy to take questions, Chair.
Thank you very much for that, Christopher. Thank you, Darren. Okay, so the paper states that it's normal practice for an LCM to be provided on bills in advance of them reaching reporting stage in the House of Commons. So I presume the bill has been going through stages in the relevant stages in the House of Commons for quite some time. I'm just interested in why we're only being advised on the need for the LCM at what some might consider to be the last minute.
Yeah, no, I can only sort of apologise for that, Chair. So it's a PMB, and I guess the issue here is that the UK government decided to back the PMB and give it government support at its second reading. Minister was then approached and asked if he would want to undertake the legislative consent process in February. We confirmed that in March. There's a number of internal clearances and approvals that had to be achieved. And then it had to be referred to the executive. I think in hindsight, if I were to do things differently, I would have approached the committee at the same time as I approached the executive, and that would have saved an awful lot of time. Look, I'm quite content to sort of review the processes personally, and I would like to sort of assure the committee that I'm happy to learn lessons from that, and I am quite happy to take the criticism as well on that.
I appreciate that, Christopher. That's very refreshing, actually, but I do appreciate that, and I do agree. But in regard to, so I have two other questions. So in regard to the elements that aren't extending to Northern Ireland, one of them I think is the measure to restrict the age at which dogs and cats can move into Northern Ireland, because it's deemed to be contrary to the EU pet regulation 576/2013. And which applies to Northern Ireland as it's contained within the Windsor framework. Could you clarify that for the record and detail any other provisions which don't extend to Northern Ireland, please? Yeah,
so you're correct. It is the 6th month age limit, and it is the ability to restrict animals that are pregnant. Those are the sort of the two main aspects of it, and obviously the other aspect, Chair, is the dropping of what is deemed to be a personal import. The numbers acceptable as a personal import from 5 to 3. Those are the three main elements of the bill that will apply in GB, but not to Northern Ireland. I guess, as I indicated in my opening remarks, we don't particularly see any policy difficulty with that. So if there was a free hand, to use that terminology, to make those, or to implement those policies in Northern Ireland, I'm not sure that those would be policies we would have recommended to our minister, or those are policies or proposals that would have actually solved a problem. I don't think we have that particular problem in Northern Ireland. Um, um, Around personal imports, we don't have that particular problem in Northern Ireland with people trying to circumvent rules bringing in pregnant animals.
Would it be fair to say that we're in Northern Ireland? We our sort of part in this is more to do with the export. We probably export, and in terms of what this bill will do is to protect dogs from entering England, Wales, and Scotland from here, perhaps. So, whilst that law doesn't apply to import, it will absolutely apply to export to GB.
No, I want to clarify, this does not impact any internal movements in the UK at all. So there will be no restrictions on animals aged 6 months or pregnant, or the 3 to 5 limit from going between sort of Northern Ireland and GB. That won't come into play. Just to sort of elaborate, the provisions brought forward by DEFRA are primarily to tackle that issue that they encounter in the southeast of England, where they are getting traffickers pretending that consignments of pups are their own personal imports. So the typical scenario which DEFRA officials are encountering at the channel ports is a van will drive up. There will be 3 people in the van. They will have batches of animals in the dogs, or dogs in the van, and they will all claim that these are their personal pets, and they will use that to circumvent the proper legislation on importing pups into the southeast of England. So it's a very definite set of policies there to deal with that particular scenario. When they have tightened up on the trafficking of pups into those channel ports, they then saw this phenomenon whereby people brought the pregnant dog instead, and that is why they're trying to bring forward that restriction on bringing or importing pregnant animals into Northern Ireland. The other thing I think, Chair, is fair to say is we wouldn't want to ever sort of invoke any policies which impinge upon the movement of animals between ROI and Northern Ireland legitimately. Sort of there is quite fluid movement of people going between both jurisdictions. And for example, I don't think it would be helpful to restrict the ability of somebody to bring a puppy into Northern Ireland that was less than 6 months old.
Okay, and just again, this is teasing this out very well for me actually. In terms of any illicit movements we have of pups, pregnant dogs, or any dogs of volume on this island or across these islands, then does that mean that these powers don't have that provision because this extends purely to imports into the UK from other areas, particularly the EU?
Yes, so the whole bill is predicated on imports from beyond the UK into GB, or in the case of the mutilations, beyond the UK into the UK as a whole, and Northern Ireland. And just again, to add a little bit more detail around the sort of the normal scenario that we see in Northern Ireland around trafficking. I think, as a sort of you said, we unfortunately we've tended to have been seen as a hub of puppy trafficking. They tended to be either sort of indigenous illegal breeders here, moving animals through Larne and Belfast to the bigger market, the more lucrative market in GB, or coming across from sort of the Republic of Ireland into Northern Ireland. But that has been in van loads. Unfortunately, it's not 3s and 5s. It's van loads. However, I would like to stress that we have had the Pause for Thought initiative in place since 2020. That has been very effective in dealing with Northern Ireland being used as a conduit for puppy smuggling. We have seen puppy movements through our ports drop from around 20,000 movements in 2020 to around about 9,000 last year. So we do have separate initiatives, Chair, to deal with the public smuggling issue in Northern Ireland. They are very effective. It's not eradicated. I don't think we could ever eradicate it, but we have made a pretty hefty dent in it.
I appreciate that. We do know that smugglers will go out of their way to usurp anything that we do. And my final question, if you don't mind, is on the criminal offences. So the criminal offences, in terms of the sentencing, are in line with, like you said, the 2011 Animal Welfare Act.
Yes.
Are you aware of any moves to look at the legitimacy or the weight of the sentencing in regard to this? Because it would strike me, and not to be too party political, but we do have an issue with very lenient sentences, particularly in regard to cruelty on animals.
Yes, we've done a lot of work in the past year or so around sentencing, because we are aware it's a really emotive issue for MLAs, and it's been a priority issue for our minister. We have had engagement with PPS to understand prosecution routes and why certain offences end up in certain courts under the Welfare of Animals Act, and there is ongoing engagement with DOJ and the judiciary around sentencing and the powers used. I want to sort of stress that sentencing powers and how they're utilised are up to the judiciary in Northern Ireland. They are independent. They sit outside the department's influence, and Minister Muir has no influence he can bring to bear on that. However, that engagement is ongoing. When we spoke with Public Prosecution Service, they were of the view that the sentences and offences and penalties available under the Welfare of Animals Act are quite stringent when compared to similar offences, and I guess the maximum penalty that is available under the Welfare of Animals Act is a 5-year custodial sentence. So we have reflected many of the concerns raised in the chamber and reflected to Minister Muir by stakeholders and correspondence. There is a sort of process ongoing with the judiciary, DOJ, and all the other key players in this particular area to sort of learn more about how offences are prosecuted and how we can kind of reflect the concerns of citizens to those people.
Thank you very much, Christopher. Deputy Chair, Declan.
Yeah, thank you. And thank you for your presentation. And whilst obviously we have our own devolution arrangements here, and in most cases we prefer to bring forward our own legislation and scrutinise it appropriately. I do recognise that this is a very serious animal welfare issue, and it's important that legislation is brought in to deal with this sort of trade. I suppose one of the questions: see any legislation that is coming forward for us here, will it be subject to full scrutiny of by the Assembly and the committee and all?
Yes, it definitely will be. So that we gain an enabling power, and I want to stress we're not changing any legislation immediately. If legislative consent was given for this particular bill, it provides us with those enabling powers, and that those enabling powers would enable us to bring forward secondary legislation through the Assembly, and that would be via affirmative resolution. It would go through the complete policy development process. It would be subject to public consultation, and then ultimately, in order to get passed, it would be debated on the floor of the House.
Thank you. And just as well, you mentioned then in your briefing that the South of Ireland banned the imports of dogs with cropped ears. That's from 2023, and that obviously gives a parity, as you said,
yep.
North and South. Is there any other areas where there actually would be a policy divergence in terms of how we would operate, certainly here or indeed in Britain, compared to the South of Ireland?
Not particularly. I guess the desire for Minister was to get the legislation and the powers to deal with these particular mutilations, being very mindful that the Irish government had already moved on that, and I think very mindful as well that England, Scotland and Wales could move. I think he didn't want to see Northern Ireland being left behind or left out in such a fashion. And I think potentially also concerned that maybe Northern Ireland could be used as a staging post to bring animals in to other jurisdictions, and if we didn't have sort of legislation in place here and bypass the legislation that sort of has been brought in either Ireland or will be brought in England, Scotland and Wales.
That's great. Thank you, Chair.
Thank you very much. And Patsy?
Thanks very much, Chair. Just a wee, I suppose, linguistic thing. The draft legislative consent motion, if you could explain to me, please, the difference between the wording which says this Assembly endorses the principle of the extension to Northern Ireland of the provisions, and on it goes, and the wording that this Assembly endorses the extension to Northern Ireland of the provisions within the bill. One seems quite, how would you call it, woolly, and the other would be definite, and because later on in the draft legislative consent motion it enables the making of legislation and all that within the North. So I'm just wondering what the relevance of the three words "the principle of" means.
Look, I'm quite happy to sort of take that away and look at that, Patsy. That might have been just an error on my behalf.
It's just, if you could please, because it kind of in my mind alters the meaning of the LCM.
I want to assure you it is the consent of the House that we're looking for, not the in principle. We're looking for the consent of the House.
Okay, thank you.
Thanks, Patsy. And William.
Thank you, Mr. Chairman, and thank you for your presentation. Clauses 4, 5 and 6 of the bill do not extend to Northern Ireland. This could raise concerns about Northern Ireland having less stringent requirements than the rest of the UK. Is the Department content to allow a regression in standards in Northern Ireland?
Yeah, I can probably just sort of refer to sort of my previous answers, really, in that whilst our hands are tied in respect of the legal position, when we look at the sort of the policy situation and the patterns of movements on the ground, we don't particularly see an issue with restricting or not being able to restrict personal movements from 5 to 3, or the provisions relating to pregnant animals. As I said earlier, these are not necessarily patterns of movements or aspects of puppy smuggling that we see in Northern Ireland. Any particular sort of movements that we see tend to be sort of large batches of movements. We tend to be unfortunately having an indigenous puppy trafficking industry in Northern Ireland. We're not somewhere that is subject to animals being directly sort of brought in into Northern Ireland in the main.
Okay.
Bit of William. And Thomas.
Thank you, Chair, and thank you for your presentation again today. Clause 1, Northern Ireland's been treated differently, and clauses that my colleague mentioned aren't applying to Northern Ireland at all. Is that simply because there's a problem due to EU law applying here in Northern Ireland that's not being applied in GB?
That's the primary reason is the intersect with EU law. That would be correct, but again, I can only sort of reiterate my previous answers that even if there was the opportunity to look at this holistically, I'm not sure that these would be sort of policy measures that we would bring in, and I'm not sure that we have those particular problems that need to be solved the way that they exist in England.
Would this be a good position for Northern Ireland to be in then?
In terms of
being treated differently than the rest of the UK?
I can only sort of really go back to my previous answers. I based on sort of the examination of illegal puppy movements into Northern Ireland, there isn't particularly a problem that would have been solved by necessarily applying the legislation or the amendments that England are bringing forward. They really are, and they are really well set out in the explanatory notes of the bill. They really deal with scenarios that are specific to England and issues that they particularly encounter at the Channel ports. So I take your point. There is our hands are tied in respect of the Windsor framework. We don't necessarily have a free hand in that particular area. However, I don't particularly see the outworking as being negative on Northern Ireland.
Could I just on one point of clarity, Christopher, you said that you wouldn't. One of the aspects, I think it's in around. So I think you outlined the three specific differences. One of them being, say, a pregnant bitch dog, for instance, that the restriction would apply EU to GB, but wouldn't apply from Northern Ireland to the mainland. So if a smuggler then wanted to, being devil's advocate, wanted to continue that, but they could legitimately do it, say from France to the Republic, change of ownership to Northern Ireland, and then there'd be no restriction on that internal movement because those rules don't apply from Northern Ireland to GB. So the law could be circumvented. Is that fair?
I think that scenario, Chair, could come about. I would also stress as well, there are other protections under welfare during transport legislation about transporting animals in their final stages of gestation. So that there might be other legislation which would catch that. But I do take your point.
Could I also ask on this one, because I'm interested in why you wouldn't have been suggesting that would have been one that the Minister would have wanted to be interested in, even for ourselves to do. It would occur to me that not transporting a pregnant animal would be good animal welfare. And is that one that you did I pick you up right, Christopher? Did you say it's one that you wouldn't have been necessarily recommending to the Minister?
Yeah, the island of Ireland as a whole, unfortunately, does not tend to be two jurisdictions which see the influx of pups from traffickers from the EU. So generally, the illegal puppy trade in GB is fed by two routes. The southeast and south of England are fed by illegal traffickers moving dogs from primarily Eastern Europe. The north and west of GB, so basically Scotland, Northern England, and Wales, that particular illegal trade is fed by either illegal breeders based in Northern Ireland or illegal breeders based in the Republic of Ireland. So the reason why we don't particularly see this as an issue for Northern Ireland is because this is about direct imports from this bill deals with direct imports to the UK. We don't necessarily see movements of direct imports of pregnant animals. That doesn't tend to be something that happens in respect of sort of puppy smuggling.
To be fair, it doesn't happen because the market isn't here. The market is in the southeast of England, as has been pointed out. So what I'm getting at is that smugglers who have no compunction, no interest in animal welfare, but in terms of their profit, if a door closes, they will find another door. Is my point, and that if it's a route that doesn't cause them, or an option that doesn't cause them. Not only would it not cause them too much logistical difference, but they could actually be doing it legally, potentially, because the legislation would allow them to do if they could get ownership in Northern Ireland. They could transport a dog almost legally, and I think that the pregnant one is something that obviously we maybe can't do in this LCM, but I think it's something that I'd certainly be interested in from my aspect, from that aspect. I think the door sort of nearly opens, unfortunately, because I mean they're making big money.
I'm quite happy to follow up, Chair, with what and contact colleagues in DAFM to ascertain sort of what checks they have on pregnant dogs and other animals coming in to the south from continental Europe.
Is there any, what's the scale of it, Christopher? What's the scale of the illegal importation of dogs that's led to this private member's bill?
There's significant concerns about trade from Eastern Europe. The appetite in the market for puppies and dogs in GB is significantly big.
And then I'm going to finish in this one. There's also the human health concern, because we've had an instance of rabies. This week, I don't know if anybody's picked it up on the news, but a holidaymaker, it wasn't from Eastern Europe, it was from Morocco, picked up rabies off a dog, and I think there's other, obviously we don't have rabies here, which is fantastic, but we need to ensure that we don't increase the risk by possibly opening up a further import route. But listen, are there any other questions from the members? Have you anything else to add, Christopher? Darren, you've been very quiet. So you have, Aoife, have you any questions?
I'm happy enough. Declan asked the question there, and everybody else is, I'm 100%. Thanks anyway.
No problem. Darren, we'll get you next time. That's really well. Thank you so much. That was a very, very worthwhile briefing, albeit a bit late, and it's certainly given me a few other queries and questions that I think I'll be returning to. Thank you very much, gentlemen.
Okay. Thank you. Yeah, thanks.
Okay.
So, I'll just say the deadline for responses from the groups is Monday, so we'll wait and see, and we'll bring a draft report. report next week
Yeah.
and see if members want to.
As I alluded to before there, guys, we had written out to a number of animal welfare charities and organisations. The deadline closes on Monday, so up until that closes Monday, and then obviously if and when they respond, then there will be a report put together at that stage, and we will return to the item, members. Okay, thank you very much. Thank you. Okay, item number 7 is the departmental oral evidence session, the dilapidation bill. We're going to refer you to the following papers: the department briefing starting at page 107 of the pack, a brief outline of the bill starting at page 111, and the regulatory impact assessment starting at page 115. I'll also refer you to the redacted correspondence from an individual regarding the bill starting at page 131 of the pack, which highlights the issues of several derelict sites in Tandragee. Members, as you're aware, the dilapidation bill is to provide all district councils with a Northern Ireland-wide enforcement regime to deal with the negative impact of dilapidated, dangerous buildings and neglected sites. And now welcome the following officials to the meeting and invite them to brief the committee. We have Simon Webb, who is the bill lead on Neighbourhood Environment Quality Branch, and Mark Allison from the bill team, the Neighbourhood Environment Quality Branch. So I'm just going to invite you now to brief the committee. Thank you, gentlemen.
Thank you, Chair. Good morning. Yes, the dilapidation bill is intended to give councils a modern suite of powers to deal with dilapidated buildings and neglected sites. Currently, the legislation in Northern Ireland is very disparate geographically, with different powers available in different council areas. And a lot of the legislation actually dates back to the Victorian era, and some of it actually has issues in respect of human rights, making it unworkable. So the intention of the bill is to give councils the new powers equivalent to other jurisdictions elsewhere in the UK and Ireland. And this will should enable councils to tackle dilapidation at an earlier stage through the likes of maintenance notices, but ultimately to reduce the overall dilapidation to the building stock through a hierarchy of notices that will deal with different levels of severity of dilapidation. Okay. Take questions.
Yes, okay.
Thank you.
Thank you so much. So, members, your briefing paper starts at page 107 and then finishes at 115. So, gentlemen, the consultation exercise was in 2016. Has much changed in regard to the proposals since then, and in terms of the feedback from the consultation, and did it lead to any significant improvements or challenges?
No, the responses to the consultation were broadly supportive. There's been cross-party support, very much welcomed by respondents to the consultation. There haven't been substantial changes to the policy since the public policy consultation. It remains the case that we have a hierarchy of notices, and that we have included cost recovery provisions for the councils, which is a significant piece that's been added to this new legislation, which doesn't currently exist, and will make it easier for councils to recover their costs where they do step in to undertake works.
In terms of so obviously these powers will be conferred on councils. In terms of the response from councils, has that been, are councils all in the same space, shall we say?
Yes.
Yeah.
Yes, they would be, and we did write more recently to Solus CNI, to the chief executives of the councils, to ensure that they were still supportive of progressing with the bill through the Assembly, and that support remains in place.
Okay. Now, I noticed that the bill aims to bring in discretionary powers for councils only. Is there a reason why they're discretionary powers, and were mandatory powers considered? And is there a risk that you would still get a different approach in the councils because the application of discretionary powers could mean that we have regional disparities?
So yes, there are resource issues, obviously. In this particular case, councils will need to adequately resource their own arrangements. So there will be cost implications potentially associated with taking forward enforcement activity if they wish to avail of the new powers. So if these were mandatory, then there would be an issue around providing direct financial support potentially to the councils to assist with that. Taking this discretionary approach obviously means that councils can use the powers as their resources permit, and the cost recovery provisions will facilitate that by ensuring or reducing the risk that councils are left out of pocket financially where they do choose to step in.
Is there an inventory, either held centrally or by councils, of all the dilapidated, what would constitute a measured and quantifiable dilapidated property? And if there is it separated into private tenancy, private, public owned and so on?
There isn't an inventory as such of actual properties, but we did have an Ulster University study carried out in 2017, and that study estimated the number of properties affected and did indeed break it down. So happy to share those figures with committee at a later stage. Yeah,
I appreciate that. I know certainly even in the street where I am, which has seen some upgrade over the years in Bridge Street in Lisburn, it's an old street, but there are still a number of properties which the council are wrestling with because they've become desperately unsafe. My final question then is, obviously you'll understand that this committee is charged with interrogating and ensuring that rural affairs get a primary focus. So was there anything from the consultation or in the interim period which you can present to us today with regard to the impact in rural areas in particular?
There wasn't anything specifically that arose in relation to rural properties. The thrust of the bill, however, is on improving local amenity. So a property needs to be having a negative impact on the local environment, the local neighbourhood, other neighbouring properties. So it is unlikely that a council would take action, for example, on a remote property that was, say, standalone, that wasn't posing a danger or a negative impact on another resident of the council. So this will probably more affect sort of villages, towns and cities where there is closer proximity.
Another question, because you've just raised a wee point of interest for me. Now, this isn't anything to do with you guys, so I'm not blaming you. But we've learned this week that when it comes to noxious smells, the department's rules centre in around a sniff test, which apparently isn't good enough because if you don't have a sense of smell, you'll not find a problem. In terms of the test for a dilapidated building, which is causing, or it has to be quantified as measuring, is the test robust enough, and will it be applied equitably across council areas?
Well, there's no sniff test that can confirm that much at least. But yes, you'll be talking about building control officers here. Obviously, the guidance, the statutory guidance which the bill requires, we go into more detail around those elements. Mark, do you have maybe anything to add on that one?
Yes, we intend to, we've just started on the guidance, drawing on the guidance available to local authorities in England and Wales. And obviously we'll be setting out sort of case studies and stuff like that, where we'll be pointing councils down the road of what they should be doing. So that would, we would hope that the guidance would provide a very robust.
Okay, that's fine. So it's grand still to be. We can feed into that, and then my final. I'm sounding like Patsy now. The final. I mean, the direct correlation here with the transformation of our town centres is unequivocal. Like it's really like, is there any deliberate link into the sort of the prosperity of our town centres in terms of a wider strategy, perhaps?
Sorry, could you just repeat
that? So when you look at our town centres, for instance, the dilapidation of our town centres is part of the lack of appeal for bringing people back into our town centres and driving that local economy. Is that sort of an unintended consequence, or is it something that's directly impingent on this?
I appreciate the question. Yes, it's this is addressed to some extent in the regulatory impact assessment, and the thrust of the bill again goes back to local amenity. So the bill itself is not a focus specifically on economic regeneration or a certain level of properties coming back into use, etc. It is more about improving the local amenity so that there isn't that negative impact on neighbouring properties. But as a spin-off effect, yes, there would be an expectation. You've broken window theory, of course, where if you've one broken window in a neighbourhood, that can spiral. So it's about getting in, tackling low-level dilapidation through maintenance notices, so generally improving the appearance, exteriors of properties, but also tackling those properties that have become more severely dilapidated over the last few decades, and that in turn should make areas more attractive for economic activity, footfall, tourism, etc.
Thank you so much. Thank you very much. Declan.
Thank you. Thanks for the presentation. I just want to sort of pick up on the costs, particularly the potential cost to councils and ratepayers, obviously. What level of support will there be for councils to assist, from the department to assist in the challenges around tackling dilapidation?
So The approach that the bill adopts is to place primarily the cost of the remediation works, whether it's minor or severe, on the property owner or occupier or interested financial organisation or party. So the idea is that there shouldn't be an impact on the public purse in the round. So councils initially could, for example, serve a maintenance notice or a dilapidation notice requiring the property owner to take action. So there would be no significant cost there to the council in terms of undertaking works, etc. We'd be in the more capital programmes. However, if the owner does not act on that notice and is in breach of the notice, then in the case of a dilapidation notice, the council can seek a court order requiring the owner to act. And if there continues to be a breach, then the council has the option to step in and undertake the works itself. But in those circumstances, until those costs are recovered, they are a charge on the property. So the council would ultimately have the ability to recoup its costs when the property is sold. That's if it wishes to step in, if it thinks it has a realistic chance of recouping costs in a scenario where it's undertaking the work itself. Alternatively, it could place a charge on the property requiring a future owner to undertake the necessary works, in which case, again, there would be no impact on the public purse for the council.
Yep. I noticed that obviously in clause 12 it says that may recover its costs in the relevant person where it has taken the necessary action itself, which is grand. But we've seen this limbo scenario with unadopted developments where the developer has went bankrupt or has disappeared, and the bond which has been lodged will no longer complete the works that are required to complete that development. How will that work in a scenario if the council exercises powers under clause 12 to carry out the work themselves, but there is no way to recoup that money? Will that not end up being a significant cost to the ratepayer?
Yes, in that case it could be, if the council were to choose to act with little chance of recovering its costs. So councils would need to obviously act in their own self-interest when it comes to their financial situation, and they look on each case on a case-by-case basis and say, well, if we pursue this particular case, what are our chances of actually recouping our costs, or are we going to leave a significant hit for the ratepayers? There is the possibility of putting a charge on the property, as I say, to recoup costs at a later date. And the council could seek a possession order through the courts ultimately to enforce a sale if the court grants that possession order. But again, that's on a case-by-case basis, so the council would have to weigh up its likelihood of the court order or the possession order being granted by the court.
That's perhaps great. Thank you very much.
Thank you, Declan. Patsy.
Yeah, thanks very much indeed. Just maybe before we go on to the process of what a council could go through, is your definition of amenity solely visual?
Mark, do you want to comment on that?
We don't define amenity in the legislation. It's not defined in GB either.
Right.
It's sort of takes its meaning from the dictionary basically, and I think that there'll be stuff in the guidance about amenity.
But it would be generally quite broad in terms of we would expect its interpretation of what amenity actually means.
Well, I've dealt with other planning cases where amenity is much broader than just solely visual.
Yes.
So that's why I was asking, because if you're starting from that benchmark, you could rule out other options around the structure of a building. That brings me on to the second bit. What role does the HSC play in this, Health and Safety Executive?
Could just wind back just on the point about the visual amenity. There are other notices in the bill where you have dangerous structures notices, and you have the defective premises notice, and you have the ability to take emergency action. So in those, obviously, it's much more than just visual amenity, but the visual amenity would be more of a focus for the maintenance notice and the dilapidation notices in the bill. So sorry, I just wanted to clarify that.
But usually there's buildings like you've seen there's usually a bit of a multiplicity of factors. So, and that brings me on to my next point then. Where does the Health and Safety Executive factor into all of this? Because as you see, some of those buildings are just barely propped up.
Yes.
And I'm just wondering where or at what point, or if you see a role for the HSE in tackling this as well.
That's okay.
So there isn't a direct reference in the bill to that. We're not looking to impact on others, other agencies or departments.
Right.
In that respect, the dangerous structures notices and the emergency action, etc., will obviously potentially entail HSC, but no change to what we currently be the arrangements. Do you want to?
Yes, I think there, I recall in the guidance a wee bit of put in about, you know, the council will seek out, you know, the professionals in whatever, you know, field to make their decisions.
All right, but could you just talk me through the process then? So, a couple of buildings identified. One's probably more, well, from the visual, it's more dangerous than the other, but maybe inside it's more structurally defective. I don't know either of the two buildings. So, can you talk me through the process then, the discretionary process for council? Property identified, properly determined to be defective, deficient, whatever it is.
Yep.
Then what happens?
So I think we're maybe in this case probably talking about the council issuing a dangerous structures notice, and the structure, the notice will require certain works to be undertaken, either demolition or securing the property satisfactorily to remove the danger. There is the option then of pursuing a court order if the property owner has failed to act. Mark, do you want to maybe add any more onto that bit?
Yes, for the clause 10, the emergency action, the council will go in and take immediate action if it thinks that it's justified.
There's a wee bit there, sorry for just rewinding a bit. What if the owner of the property can't be identified?
In the wording that the council will take all reasonable steps to find someone.
Yes.
And that, you know, obviously it's an extreme situation, but it will go ahead and do whatever.
No, I've been there. I've
Yeah.
been there whenever I was on the council a few years back.
Yeah, it's not just
where
gonna wait.
that was in fact the case. The owner couldn't be found or determined who was the owner.
Yeah.
So what happens then? Just
Well, in the case of the emergency action, the council will go in and do the necessary work. It won't be sitting.
sorry, I get that, Chair. Just with your forbearance, that then accrues quite a bit of costs to the council, and consequently the ratepayer. So, if you can just talk me through then the legal process whereby, if there's, we'll say these court cases, some of them can wind up 20, 30, 40, 100,000, God knows where they'd wind up. So we'll say 40,000 is the cost of all the legal, and then they move on to the remedial. That could maybe be another 60, 70, 100,000. You could maybe wind up with a bill, we'll say, for a round figure, 150,000. So, and you don't know and can't find out who the owner of the property is. Where does that go? Or I'm trying to get my head around this. Who is that bill lodged with for first charge on the property legally? Where does that go, so that if anyone tries to acquire the property, or if eventually the landowner or the property owner shows up and says, hey, that's mine, and tries to flog it off or build on it or whatever, what's the process then, please?
Well, then we can go back to the, you know, putting the charge on it. That whoever.
But no, that's the bit I'm unclear about. Forgive me, just I'm unclear. You go back to putting the charge on it. By this stage, the property could be sold. That's what I'm trying to get at. What methodology is there to ensure that the cost that a council, the outlay that the council could have, would be redeemed, and the council would have first charge in the property? Is that a matter for the court to do? What way does that happen?
Well, the council has the option then to put the charge via the land registry, and whenever it comes to be sold, that charge will be treated.
Right, that's grand. That's just what I wanted to know.
Like a mortgage.
Okay, thank you. Thanks, Chair.
Thank you so much. And William.
Thank you, Mr. Chairman. And I have some sympathy for and agree that something needs to happen. There are dilapidated buildings. I have one that comes to mind that's lying idle for 20 years, and neighbours are infested with rats and stuff. It is an issue, but I can see this legislation being fraught with difficulties. This will not be straightforward because you have a legal owner of a property. If he decides not to, in the past, he decides to leave it the way it is, it's going to be very difficult. I think, even from a legal perspective, it will be very difficult. Have you used anything? Is there any legislative review mechanism in the bill to assess the effectiveness of the bill when it's up and running?
So the bill, just on the issue of the level of action or how difficult that might be, the council will have a suite of these notices available. They can use a combination of the notices, and that can be on an owner, an occupier, an interested financial party. And they also have fixed penalty options available in this, and there are also criminal offences around fines and custodial sentences. But on the issue of effectiveness, there would normally be, for something of this nature, the usual post-project evaluation, usually around, it would normally be about a year afterwards for most projects, but I think for something like this it would be a longer term, so that you can see.
My view is getting it right the first time might be difficult. And they may need to be looked at again, because this won't be straightforward in my eyes.
Yes, no, there would almost certainly be standard reviews for something of this nature, but because of the type of work involved here, it would probably be after a number of years to allow this to bed in and see what enforcement activity has been undertaken, and to see if there has been an improvement in the overall condition of the buildings.
Okay, thank you.
Members, Tom, did you have anything?
Just one question, Chair, thanks. Where council steps in and notifies an owner that work needs to be done here, the occupier objects to that, and there's a problem then between the owner and the occupier, and I notice where then that this can proceed through the court. Who then takes that through the court? Is it council or is it the owner of the property?
Well, I know there's with provisions in here about obstruction by the occupier, so that they're not allowed to obstruct works. In terms of then that progressing further, the case then would be between the council and the court.
Yeah, it would be the council who push it through. Yeah. Okay, that's fair enough. Thank you.
Okay. Thank you, Tom. Aoife, have you anything there? Are you content?
I am content. I had a question, but it's already been answered, so I'm quite happy to move on.
And yes, it's evident that the timescales for the committee are going to be reflected, or most likely in the next few weeks. Okay, thank you so much for your time, gentlemen, and we will return to this in the next couple of weeks. Committee, I'm just going to pause for 10 minutes comfort break for members, if that's okay. So we'll go. Thank you.
Committee Room 21. Sound. 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 Committee Room 21. Sound.
On agenda item 8, which is the departmental oral evidence session, the launch of the draft climate action plan consultation. So members, I refer you to pages 156 to 159 of the table papers to the embargoed written statement from the Minister regarding the launch of the public consultation. This statement was embargoed until the 19th of June, which is today at 9 a.m. So members, I refer you to the briefing paper on the launch of the draft climate action plan consultation, which starts at page 139 of your pack. There is a great volume of accompanying papers in the pack, including a copy of Northern Ireland Climate Action Plan 2023 to 2027. That is at pages 149 to 416 of your pack. And now you're going to welcome the following officials to the meeting and invite them to brief the committee regarding the upcoming consultation on the draft Climate Action Plan. We have Dr. Claire Cockerill, the Director and Climate Action Delivery Division, Dr. Alistair Carson, Chief Scientific Advisor, Mr. Patrick Salvage, Deputy Director, Climate Action Delivery Division, Mr. Niall Boyd, Head of CAP Economics Branch, Climate Action Delivery Division, Martin Mulholland, Food Farming and Rural Affairs Group Representative, and Fiona Dixon, Land and Land Use Change Branch, Natural Environment Policy Division. So 1, 2, 3. We got seats for you all, did we?
No.
Oh,
Fiona's in the public gallery.
Fiona's in the public gallery. Okay.
For questions.
Good. Thank you. Okay. I'm just going to now invite you to brief the committee, if that's okay. Thank you so much.
Yes, thank you very much. So good morning, and thank you very much for the opportunity to update you on our cross-departmental work to develop Northern Ireland's first climate action plan. So the draft plan is launched for a 16-week consultation today, following executive agreement to do so. And this marks an important milestone in our journey to net zero. Our progress in publishing Northern Ireland's first climate action plan for consultation delivers a key commitment in the programme for government, and it progresses another commitment of the Climate Change Act, our first climate legislation in Northern Ireland. Minister Muir has been clear that tackling climate change is a top priority, and this committee has had the opportunity to provide input to DAERA's delivery on other key requirements of the Act, including the setting of public body reporting regulations last May, the setting of the first 3 carbon budgets, 2040 emissions target, and reconfirming our 2030 target in December, and consulting on arrangements to establish a Just Transition Commission earlier this year. So launching the public consultation on Northern Ireland's first climate action plan marks another step forward in delivering the Minister's programme of climate-related work. The draft climate action plan sets out for the first time a cross-government approach to achieving a legally binding carbon budget. It gives shape to how departments collectively intend to reduce carbon emissions in this first carbon budget period from 2023 to 2027 and beyond. Whilst DAERA leads on the Executive's climate change agenda, tackling climate change isn't the sole responsibility of the department. The legislation places a duty on all departments to exercise their functions in a way that's consistent with meeting our emissions targets, and we've been working closely with NIC's departments to achieve that. We have a number of formal governance structures to support that collaboration, including a strategic oversight group, which is chaired by the DAERA Permanent Secretary, with senior representatives from every department. And we have other operational and technical governance groups, including an evidence and analysis group led by Alistair, our Chief Scientific Advisor. The Act is very clear that delivering the carbon budgets is a shared responsibility, and every department has a legal obligation to contribute to its development by providing DAERA with policies and proposals for inclusion in the plan across all sectors. So that's energy production and supply, business and industrial processes, public building sectors on which DFE leads, transport on which DFI leads, residential buildings on which DFC leads, and agriculture, land use change and forestry, waste and fisheries on which DAERA leads. Together, the reduction in emissions from these sectors must be sufficient to meet the carbon budget. And for this carbon budget, that's an annual average reduction of 33% against the base year across the 5 years. So it's very much a whole economy approach, and some sectors will reduce emissions more quickly initially, whilst others have a slower transition due to the complexity, economic impact and need for behavioural change. The draft Climate Action Plan contains over 50 policies and proposals that will deliver change, and these include measures to increase the proportion of electricity from renewables, reduce vehicle emissions from switching fuels to electric and low-emission alternatives, reducing overall energy consumption in business premises and our government estate, improving energy efficiency in residential homes, diverting waste from landfill and increasing recycling rates, introducing a programme of sustainable agriculture measures, and increasing forestry cover and restoring peatland habitats. So the plan is grounded in the best available science. The policies and proposals put forward by departments have been assessed through quality assured modelling and quantification methodologies. Estimates indicate that if delivered as proposed, the plan will just exceed the required budget, with an annual average reduction of 33.1%. The central scenario that's been used for quantification includes clear criteria. So proposals must have a credible delivery mechanism, realistic timeframes, and either secured funding or high confidence of available funding. And this ensures that delivery is realistic to create a credible plan to meet our legal obligations. The cost of the Northern Ireland Executive Budget has also been estimated. Over 4 years of this carbon budget period, we estimate capital investment of around 718 million, or that's about £93 per person per year. But it's important to note that not all of this investment is additional. So some measures will have occurred without the Climate Action Plan, and not all investment can be solely attributed to the Climate Action Plan. So some measures will have been accounted for in the cost of delivering other strategies. While upfront investment will be required, the cost of inaction is far higher. Delay incurs the risk of having to adopt more expensive technologies in later years, missing out on co-benefits such as cleaner air, the protection of our environment, inward investment and the development of green jobs, and improvements to our health and well-being. And in contrast, this plan helps position Northern Ireland to compete for UK, EU and international funding to unlock innovation and transition in a fair and managed way. And the principle of a just transition is central. It aligns with the work to establish a Just Transition Commission and a Just Transition Fund for Agriculture, and members will be aware that the Minister secured 12.3 million this financial year to support the agriculture sector. The changes required to mitigate against the damaging impacts of climate change will touch every part of our economy, institutions and daily lives, and a suite of impact assessments has been carried out and will form part of the consultation. Results report no major adverse impacts and identify appropriate mitigation measures. The draft plan before you has been built through cooperation across departments and with a wide range of stakeholders, but we know that it isn't the finished article. The consultation is a very important part of the process, and we're keen to hear the voices of the public, the sectors and stakeholders to help inform the final version of Northern Ireland's first climate action plan. We planned an extensive consultation process that will comprise of 10 regional in-person events and 2 online events, and these will be supplemented with sector-specific sessions facilitated by lead departments to provide an opportunity to explore sectoral input in detail. The consultation will run until the 8th of October, and responses can be submitted online via Citizen Space. Given the extensive nature of the Climate Action Plan documents, a summary consultation document has been produced and an easy-read version is also available. So in closing, the launch of the consultation is a key milestone in implementing an important requirement of the Climate Change Act. It's the first time we've had to deliver this complex piece of work, and we've learnt much in the process. The plan represents the culmination of a considerable amount of effective collaboration, and it sets out a credible pathway to meeting our first carbon budget through policies, proposals across all sectors that are achievable and deliverable. So we're pleased to be in a position to be bringing forward the draft and look forward to receiving feedback through consultation. Thank you very much, and we're happy to take your questions.
Thank you so much. Thank you for the work that has went into this. I do believe that tackling the environmental pressures and failures of the past is everybody's priority, and this is subsequently a significant part of that. The consultation sets out mitigation measures for the first carbon budget. You've highlighted the potential positive impacts and challenges for rural communities, I suppose, and the report goes into that in reasonable detail. Among the challenges that have been highlighted are adaptation to new agricultural and environmental policies, without adequate engagement, training or support. As a committee, we've been discussing these challenges as we consider the rollout, particularly of the sustainable agriculture policy. A main one that I would presume is the financial support to changes in farming practice. But what do you see as the main challenges to meeting the timescale in respect of those challenges to the farming and agri sector in particular?
I'll pick up first, Martin, and then I'll follow.
The mitigation measures that we've modelled for the agriculture sector of the CAP include a range of animal productivity aspects to reduce emissions while at the same time maintaining the current level of milk and meat output from the agriculture sector. And we have already launched a number of those schemes on the beef side of things to improve beef productivity through the beef carbon reduction scheme, launched in the beginning of 2024. And the sucker cow scheme was launched a couple of months ago at the beginning of April. So there's other, in terms of the other mitigation measures, quite a number of them are being delivered through knowledge transfer and applied research. For instance, in terms of showing farmers how they can reduce nitrogen fertiliser use going forward. The CAFRE knowledge transfer staff had an open day 2 weeks ago that was fairly well reported in the press, and there's other ongoing research commissioned by DAERA with HAFBI. Recently a net zero farm research project established, and on the CAFRE farms a lot of work has gone on over the last 3 years to incorporate legumes in the swards to fix nitrogen and hence reduce fertiliser use. And the ongoing knowledge transfer on things like low emission slurry spreading, to allow better utilisation of the nutrients in the slurry and hence reduce the need for fertiliser. Other things that we're looking at is novel slurry treatment systems that would again retain more of the nutrients in the slurry to get better utilisation and hence reduce the need for fertiliser.
We seem to be pretty well advanced in the discussions in regard to how we're going to tackle it at that stage. So when we had the OEP in here, they had said, yes, to get the fertiliser and the lessy stuff and that. But one of the things that they pointed out to us was the challenge in regard to feeding, and that in terms of that balance, that feed in the feed part of the feeding for cattle and pigs and all of those type of things, that's where the significant challenge was. Has there been any work in that space to come up with solutions?
Well, in terms of, say, feeding to reduce the age at slaughter, again, there's been a wide campaign provided by CAFRE as to how farmers can reduce their age at slaughter, while without necessarily increasing concentrate feed use. Things like the management practices to decide when to start finishing animals, things like grassland management efficiency to get better weight gains of grass, producing better quality silage so that the animals will grow faster on the forage that they're eating, and improving animal health, etc., will all contribute to improving the gains from the animal's diet.
If I could just add, I think, Chair, really strong linkages between research, education and knowledge exchange are so important, in this space, because the adoption of low farming practices and the development of subsequent future climate action plans will need new innovations coming through, and that interface is really important in driving adoption. It's good that the metrics for some of the key parameters are heading the right way in terms of driving forward in terms of production efficiency, which is key in terms of reducing the overall environmental footprint from the livestock sector in particular. But we all know that integration is absolutely crucial, and that science and evidence informing the way forward in a just way is absolutely crucial in this space.
The knowledge transfer one is really important, I do believe, but unfortunately at the moment the relationship, I would suggest, between the Minister and the farming sector has probably at its lowest since the Minister took over. That's not a slight, it's just through the NAP proposals and that linkage that was broken. Is there anything that you have thought about in terms of how the relationships can be improved or repaired to the point where knowledge transfer is not just accepted but actually sought to build up that confidence again in the farming and agri sector? Because I think the knowledge transfer piece is going to be absolutely critical to achieving the targets that are outlined in this consultation.
Well, I think if we look at the targets that we need to achieve from a government perspective to meet the requirements of the legislation, that sits alongside the requirements from the marketplace for the food processors and the communication through to their supply base in terms of the reducing Scope 3 emissions. And many of our main food processors have published targets to achieve that. So I think in the long term we all need to work together on this. That is absolutely crucial going forward.
Yeah, and I think maybe Claire, if I could say, just from the science perspective, I think new programmes such as the DEFRA-funded Dairy Farm Carbon Network is a really important factor. It's got a major Northern Ireland component. It's led by AFBI with significant input from AgResearch, and developing that interface between the science and adoption through those types of initiatives is really, really important. And we've also got really good examples of case studies where European innovation partnerships went really well, and that overall dissemination of projects such as the ArcZero out are really important. And there has been considerable, and Martin's led considerable engagement with stakeholders in the development of the overall policies and proposals that have been quantified.
Very much so, and as where Alistair is referring to the Dairy Carbon Networks project, we have worked very closely with DEFRA colleagues in terms of including Northern Ireland specific requirements within that project, going beyond reducing greenhouse gas emissions but also to reducing ammonia emissions through measures such as reducing dietary crude protein, and from a Northern Ireland water quality perspective reducing the phosphorus content of feeds. And the feedback I've got from the other research organisations involved in the consortium of the project. They've seen that, yes, they need to do that in Great Britain as well as the focus we're putting on those issues in Northern Ireland.
Right. I think there's a great deal of work to be done to ensure that we have the relationships are right for the knowledge transfer piece. Having the sense and all that is okay, but if you can't get it delivered, it'll not mean a whole lot. We had the OEP in here a few weeks ago, and the OEP had been asked a question by one of the members in terms of whether they, in terms of their targets, had to consider the rural impact assessment or the dichotomy of pressures on the sector, and they were quite clear, said no. Their legislative function was to create and to assess against the legislative targets. They also indicated that herd reduction was something that they saw as a component part of achieving the reductions that they would want to see. But the Minister obviously is the Minister for Agriculture and Rural Affairs and the Environment, so it's quite difficult for the Minister and the Department to achieve that. How do you see it being played out that we do achieve that 33.1% in the 4 years, possibly hopefully within budget, without seeing any diminution or reduction in our farming and agri sector? And a part of that question, and this will be my final one, is that I know that we have talked about green jobs in rural areas. The final part of that question is the green jobs in rural areas seen as a displacement of farming and agri or complementary to the rural offering?
Maybe just if I start and then maybe ask Paddy to come in. So in terms of the deliverability of the climate action plans, we've engaged with all departments who've input their policies and proposals. And those policies and proposals have been put forward on the basis of criteria. So it's criteria to ensure that it is achievable and deliverable. So in relation to the cost aspect of that, those policies and proposals are those which have funding in place or a high likelihood of funding being available. So from that perspective, the policies and proposals within the Climate Action Plan are those which we do see are deliverable within that 4-year period. Specifically in terms of the agriculture, I'll maybe ask Paddy to come in.
Yeah, so specifically on that 33.1%, I mean, effectively that is the policy and proposals that are in the draft cap, the assessment that has been done on those across all sectors, and that has identified that our projected emissions would achieve that 33.1% average annual reduction, which meets the carbon budget. So I suppose effectively how we meet the carbon budget is simply by implementing what is in the draft cap. In relation to the agriculture sector and the question you asked around livestock numbers, the Minister has been really clear that the advice that has been received from the CCC around mandatory reduction in livestock numbers is not something at this stage that he is taking forward, and that, as Martin had alluded to, the policy is to maintain output of from beef and dairy, but by delivering greater efficiency and therefore achieving the reductions that have been set out in the report in the agriculture sector.
Well, just for clarity on that, there's a bit that I want also that if you could touch on is we see the green jobs in rural areas pitching up. So I'd like to know that the departments, did they see that as displacement and rearrangement of jobs that already exist in farming and agri, or is that a bonus? Does that seem to be an additional part for the? Because it's obviously it's in the consultation as part of government documents. Obviously, it's an ambition there, which is good. But on that piece on herd reductions, for instance, I'm trying to understand how collective the department is in regard to its different functions. So we have the NAP proposals that are out there that the Minister's now said that he's now listened to and he's going to do something different. But those were drawn up with this in view, and by all of those in the industry, they said this is going to lead to herd reductions. This is undeliverable in its current format. Is the department collectively engaged to deliver on this if they're coming up with something which is undeliverable, and I'll use NAP as an example, to achieve the targets of 33.1% in particular, and then possibly even more difficult targets to meet in the next phase of maintenance requirements?
In terms of the green skills and green jobs, so we've been working very closely with the Department for the Economy. They've been doing some analysis just looking at skills and skills development, what is required. And we're, the Green Skills Action Plan, for example, came out, and that's a really positive development. So that's putting in place measures that will help to ensure that those gaps are being addressed. So, I mean, in terms, we do see it as opportunity. There is opportunity in terms of the wider rural economy. So, and it's something that I think through the draft climate action plan, you know, can be addressed. Within the rural needs impact assessment, that's something that's been considered, and the opportunities for green jobs and development of those green skills is seen as a positive impact. I think one thing that in the mitigation measures we will just have to continue to work on is just ensuring that there's accessibility to that training that's regionally spread. So that's something that will be addressed going forward.
And then the correlation of things like NAP, you know.
Sure.
When
Yeah, well, there's some measures in terms of mitigation measures that impact on nutrient loss to waterways and to greenhouse gas emissions, and where there are, you know, win-wins associated with them because they're cutting across both. So, for example, reducing and through precision nutrition, reducing the protein content of livestock where it can be done without affecting overall production efficiency, reduces overall nitrogen losses to the environment. Within our mitigation measures, reductions in fertiliser, nitrogen fertiliser, inorganic fertiliser is one of the measures. Now, that's not driven by the overall NAP regulations, which are just to make sure that nitrogen isn't over-applied above overall crop requirements, but to have major initiatives through the industry in maximising the use of legumes to drive efficiency on farms through that way itself. Measures such as LESI, which aren't actually quantified, you know, in the main bits, can have, you know, advantages. So obviously LESI is primarily around reducing ammonia emissions. But in doing so, there's the ammonia emissions. Also, there is longer scale nitrogen deposition, which can increase nitrous oxide, which is a greenhouse gas. So there's some indirect benefits. So there is measures which cut across, and in terms of improving overall environmental metrics. From the livestock sector, but I don't see them in a juxtaposition, or that there's a barrier that would be creating major obstacles to the delivery of the climate action plan. But nonetheless, it does represent, you know, significant change and continued change in the industry as we look to, you know, develop the overall sustainability and environmental credentials of the sector.
And final one, I don't want to trump on anybody's toes here, but in terms of anaerobic digestion opportunities for either creation of energy or the gas network, it would appear to me that DAERA is much more ambitious than another department in terms of what they're looking at. But has there been any significant collective work in regard between DAERA and the Department of Economy to, I'm not going to say turbocharge at this stage, because we have to be very careful when we move into the energy sector of how we would do this, but it seems to me that whilst it may not be a silver bullet, it could be a significant enabler for meeting our climate credentials.
Yeah, I mean, you'll be aware of the sustainable utilisation of livestock project. So that is ongoing. That's work that DAERA is leading, but we are working extremely closely with Department for the Economy on this. So there's a lot of engagement on this issue, and you know, as the findings from the SBRI on the sustainable utilisation of slurry come forward, you know, we're learning lessons from that. It's really important that that's part of DFE's, you know, wider energy agenda. But there is, you know, significant ongoing engagement through the likes of the interdepartmental biomethane group. I don't know if anybody else wants to comment on that.
Just to say as well, in terms of the policies and proposals within the draft cap on what we've been able to quantify and assess emission savings for, that biomethane is very much there, and it's across a number of sectors, including the business and industrial sector that's led by the Department for the Economy. So it's very much in the cap, and there are savings associated with it, projected savings
within the overall targets that we've got and we're hoping to achieve at the moment. Yeah,
within the overall quantification that's been done. Yeah.
Brilliant. Okay, thank you so much, and it was really useful. Declan.
Thank you. Obviously, this is from an agriculture perspective. There's going to be a lot of emphasis put on the farming sector. So, what type of support, like capital support or training support, is there going to be for farmers? And you touched on the lessee, and just in the context of the recent motion on the NAP proposals and around that, there, like I and others have made the point that a lot of that lessee equipment isn't adaptable for areas of natural extent, ANC areas, for example. So what support has there been put in place to support farmers, in this journey?
So maybe the starting point that is in the Sustainable Agricultural Programme itself, Martin. Maybe Claire, that Martin would touch on, and then we can move from there.
Yes, well, as I've already mentioned, we have launched the beef carbon reduction scheme and the beef sustainability package, the sucker cow element to support farmers on the beef side of things to transition in that journey towards improving productivity of their animals through earlier age at slaughter, earlier age at first calving and reduced calving intervals, etc.
And we know in other areas there will be further work required in terms of part of the just transition. So some of the new innovations that come in will need to be examined of how those could be incentivised, to ensure adoption and coming forward, such as the feed additives, for example. And those explorations are taking place, that exploratory work.
And I'm just trying to think, how will this programme balance reduction in emissions with maintaining output, avoiding carbon leakage, whilst meeting like global demand for like livestock products?
What we have modelled is to improve the productivity of the sector while maintaining the output, so that productivity improvements such as earlier age at slaughter will retain the same level of clean beef carcass output, with while at the same time reducing the emissions from animals being on the farm for a shorter period of time. And the same applies to for instance, the age at calving, both incentivised through the beef sustainability measure on the beef side of things, and the equivalent on the dairy side from a knowledge transfer perspective.
Key on that will be driving forward both on the input side but also on the genetic side. And the rumen genetics program will be key and part of driving and underpinning improved reproductive performance and overall growth performance of animals to achieve the same levels of output with reduced overall wastage in the system.
And in terms of capital investment to support that, the coming investment measure will provide grant aid for farmers to invest in better handling facilities, etc., to more regularly weigh animals, for instance, to make sure that they're meeting growth targets, etc., to help improve that productivity on farms.
Just very friendly, just in relation, you mentioned the beef scheme there, like it has been mentioned to me a few times by farmers, if you're reducing the age of slaughter, this would have a knock-on impact potentially of farmers and using additional feeds to try and beef up the cattle for finishing. So that then would encourage use of additional feed and nutrients and phosphates as well. So do you see any issues around that there? Has that been factored into the scheme?
The knowledge transfer support to farmers for the beef carbon reduction, using both calf-free farms data and benchmarking data from actual commercial farms in Northern Ireland, demonstrates that it's entirely possible to achieve earlier age at slaughter well below the incentive targets within the beef carbon reduction scheme without increasing concentrate use. As I mentioned before, improved management of such things as grassland management to increase weight gains of grass, better quality silage to get better weight gains over the housing periods, better animal health to make sure that animals aren't held back by poor health, restricting their growth rates, etc. And as Alistair has referred to, on the genetics side of things, selecting for improved genetics to improve growth rates and hence earlier ages at slaughter.
Thank you, Martin. Thanks, Chair. Thank you.
Thank you very much. And Aoife, you're next.
Thanks. Yeah, so look, thanks for everything so far. That information has actually been really helpful. Just two questions. What do you think the economic impact will livestock reductions have on farm incomes, rural employment and related industries such as food processing and exports?
Well, if we look at across all the improved animal productivity measures, all of those should be positive for farmers in terms of increasing their farm profitability if they achieve those targets. And again, in previous comments, as I referred to the work by CAFRE in terms of benchmarking farm performance, it would show that those farmers that achieve those targets will have better farm performance. When it comes to mitigation measures such as to reduce nitrogen fertiliser use, nitrogen fertiliser is obviously a large input cost, so if farmers can reduce that cost, the cost of the fertiliser, that will improve their farm profitability. It doesn't mean to say that it's necessarily easy to do, or it would have been done to a greater extent before now, but there will be a need for knowledge transfer support to farmers to achieve such things. And where some previous questions were relating to green jobs, for instance, support to farmers in achieving those sort of outcomes. If we look to what has been happening on the dairy sector over many years in terms of the increased number of nutritionists employed in Northern Ireland to support dairy farmers to get better nutrition, better performance outcomes from their dairy herd. The equivalent, I could see that happening on the grassland productivity side of things, how to best manage soil fertility, making use of data from the Soil Nutrient Health Scheme, etc., to incorporate legumes, reduce the costs of nitrogen fertiliser, etc.
Okay, thanks for that. So I think we keep hearing about it, and that we've heard that one of the requirements for the department to consider whilst making any proposal, or certainly the proposals, a good example is the NAP proposals, that it takes on just transition principles. However, we know that the Just Transition Commission hasn't been established yet. So how can these principles be undertaken, given that to be the fact?
It's a requirement, again, on all departments to take the just transition principle into consideration. So that's something that has been done for this first climate action plan. So putting forward policies and proposals, that just transition principle, which is outlined in the Act, has been taken into consideration. You're right, the Just Transition Commission isn't established as yet. There's work underway to establish that. So there was a consultation on the proposals for the Just Transition Commission earlier this year, and we're working just to get that in place as soon as we possibly can. And that will be important because it will provide advice and guidance to departments as they seek to apply that Just Transition principle. So I suppose that's something that we will continue to build on. For subsequent CAPs, it has been taken into consideration for this particular climate action plan in the policies and proposals put forward by departments, and then with the establishment of the Just Transition, hopefully soon, then that will be something that we'll continue to build on, and will be further support to departments in doing that.
Right on. Thank you very much for that.
Thanks, Aoife. William?
Thank you, Mr. Chairman. And been a farmer myself with declaring interest, been a partner in the farm business, but talked about the reduction in nitrogen fertilisers. It has already been reduced in Northern Ireland by up to 40% this last few years, and price probably dictated that. Should we not be encouraging grass-based production instead of more concentrates? The Deputy Chair mentioned the extra feed needed to kill animals. I think the target's within 24 months at the end of the day. I've farmed all my life and I can't see that been done without use of extra concentrates. No matter what your trials or what they tell you, it's impossible to do it without the use of more concentrates. Should we not be concentrating more on grass-based feed for animals rather than reducing nitrogen?
Well, there is the opportunity to grow the amount of grass and more than we grow currently with the use of alternative technologies such as the incorporation of legumes into swards to fix that nitrogen, along with some of the other management practices that I mentioned earlier in terms of...
That's going to take a massive change for that to happen, but that's not going to happen by 2030.
It is going to take time to happen, but there's already steps taking place there that I mentioned in relation to the demonstration at Caffrey. There's also, as Alistair referred to, the previous EIP ARC Zero projects that have shown the potential there, and that's being rolled out. There's also the AgriSearch work with the Zero End Silage project, looking at growing silage crops without any nitrogen fertiliser use. If we look to, there's been similar work carried out in Great Britain and south of the border, the Chuggas Sullohead farm, which is what they refer to as their wet farm, the most difficult, heaviest soils, and they're producing 13, 14 tonnes of grass with about 20 kilos of nitrogen fertiliser use, and that nitrogen fertiliser is only applied when they're reseeding.
I hope it works, but I can see the targets set out here in my eyes, and I could be totally wrong or totally unachievable. I can't see those targets achieved. For instance, do you still, afforestation, planting more forestry was one of the targets. Does that remain the case?
If that's a question, we could...
Yeah, well, maybe Fiona will pick it up, but afforestation, Fiona's covers land use, but afforestation is an increase. Afforestation is one of the measures within the land use programme of an overall target for an increased area of 9,000 hectares by 2030, and within the 2023 to 2027 period of time, the projections from Forest Service colleagues for that period of time have been quantified. Obviously, for something like a forestry, there's a lag between planting and significant sequestration. So it's really important now in terms of additional plantings for the 2050 and the 2040s and the 2050s, because that's when those planted trees have significant carbon sequestration. So whilst the plantings, during this first carbon budget don't have a significant impact on the overall, carbon reductions, they will have in subsequent decades.
I would tree planting be encouraged because I had one guy in my office yesterday and I made an appointment for tomorrow that had planted trees 20 years ago. They're full ice, die back, there's no return on the money. They will not plant trees again. So how are you going to encourage people to plant trees when there's a bad taste in a lot of people's mouths in relation to planting trees? That's just not going to work, because unless there's some big incentive for people to plant trees, they're not be doing it.
Mm-hmm. I think in terms of the quantification exercise, and of course Fiona will pick up more if appropriate, the increases in afforestation that have been quantified in this first carbon budget are relatively modest. There is a lot of policy development work to get the increased rates of afforestation to hit the 9,000 hectares target, post 2027.
I understand that, but those that have already took part in the scheme or sick to the teeth of the scheme wouldn't touch it with a barge pole again. So a lot of those people, you'll have difficulty encouraging them to plant trees.
I think Claire, obviously just making sure that we have learnings and that's fully considered in the development of new policy is really important in this.
I think it's vital that there's lessons learned.
Yeah, and I think through the consultation there's opportunity for that feedback to be provided and for that to be taken into consideration.
Okay, thank you.
And Declan, you want to come in at this point on this?
On the planting issue and the importance of it, is there any plans to re-open that small woodland grant scheme? So it's not currently open.
Maybe I can't talk to that specifically. Maybe Fiona, when it comes, can, but I can't talk specifically on that one. But we can come back to you, Declan, on it.
Also, just related to this, we're out on site last week at the peatlands, and that was one of the issues that was raised with us by the Ulster Wildlife Trust. They made the point that the department doesn't provide enough incentives to landowners and farmers to make their peatlands, their bogs available for restoration work. So I think that would be something I think should be factored into the new sustainable agriculture programme.
Maybe with the chair's position, could we invite Fiona to come and speak about the peatland, if that's okay?
Yes, no, absolutely. I think that's absolutely fine. I think it's a really interesting point that Declan has ruled in here in terms of the carbon capture and storage capacity, too, in terms of where that fits in, because there's certainly ambition, demonstration of significant ambition as to how that would impact in the wider piece. And I've just one further thing, just on the afforestation piece. I've had a series of questions in with the Department and Minister, not necessarily just around the incentivisation and around for farmers, but that wider afforestation piece in terms of the Woodland Service and the other sectors and stuff. There is a fear that the targets won't be met of the 9,000 hectares by... Now, the most recent answer I've got from the Department is that there seems to be reasonable confidence. But that would mean it would need to ramp up significantly in 2026 and literally, multiply what they've done in 2023, 24, 25 significantly. Would you have confidence in that, do you think?
I mean, that's what you've outlined is correct, and that's the basis on which we've quantified that there would be increases as we go through the climate action plan period 23 to 27, that the amount of woodland, extra woodland cover each year will need to increase, and that's the basis that has been quantified, and that's the basis of the assessment at this time. But absolutely, and I think it's a point that's relevant as well in peatland. It's just going to be critical to get the policy framework right. A lot of what's outlined in the draft cap, it sets out, I suppose, the strategic position, vision, the desire for the future, and we have put those emission savings around that and articulated what current assumptions will achieve in terms of future emissions. But it's really, really important that the practical policy on the ground is gotten right, and that applies right across the piece, in relation to all sectors, agriculture, land use, and into the buildings, energy sectors as well.
Thank you. William, did you want to come in back on this one before I bring Patsy in?
Just a quick one. I think earlier somebody said that the cost was 783 million per year annum, I think. Is that right?
718 million.
718 million.
£93 per person per year.
Where's that money going to come from?
So it'll come from a number of sources. Northern Ireland Government, as I said, not all of the measures within the Climate Action Plan are additional. So there is funding in place, or there's a high likelihood of that funding being available. Also UK Government, so there would be UK policies contained within the Climate Action Plan as well. So financial support from UK Government. Some of it will also come from private investments, and then we're also exploring other sources of funding too. So other sources such as Shared Island, for example. But we're engaging with Department of Finance colleagues and Department for Economy colleagues just to look at other sources of funding, and Minister Muir is also engaging with the Finance Minister and Economy Minister as well, so just to look for other...
So it's not nailed down as yet exactly where it's going to come from?
Well, the draft plan, as I say, has been drafted on the basis that it is deliverable, and as I say, that criteria, that actions included within it either have funding in place or there is a high likelihood that will be available. So we're saying that it is achievable.
Thanks very much indeed for your presentation. Look, we know it's all around us. We had the Storm Owen there, and that was just a blast of what climate change is happening. I have it in my own back door, the impact of climate change in Lough Neagh, and we see it all happening. But I'm just going to take you here to the financial, social and economic impact assessment, right? Now, the bit that's just glaring out of the page at me there is the assessment found that the draft cap policies and proposals are anticipated to yield long-term financial benefits for Northern Ireland, but they pose short-term financial costs. Now, that's how short-term and how long-term. Can you quantify that? That's the first thing, because short-term financial costs, that's saying who bears that? Because this is where incentivisation, whether it's for farmers, for businesses, or indeed issues that may arise in some rural areas that, like I would represent. And that brings me on to the rural needs impact assessment. It starts off with the good stuff, of course, supporting good jobs, regional balance, all that type of stuff. However, a key issue for many, because our rural areas in many instances are being denuded of services, whether that's access to GPs, access to doctors, and a key element in that is transport. Now, we'll take it on, it's briefly mentioned there. So, rural transport and access to transport is becoming even more of an issue. Whatever about climate action plans, right? However, I was trying to think there. I think I know maximum 4 people who have electric vehicles, right? And I would know quite a few people, right? And that's all that I know that have those electric vehicles. Charging points, and indeed the storm itself said, if I had an electric vehicle, where would I get it charged? So there are all sorts of issues in around that there, and I'm not quite sure. I haven't read the Rural Needs Impact Assessment, but I'll go back and I will read it if I can get access to it. If sitting in your position, as you are now as the policy formulators, or help formulate the policy and bring it forward, what would you say are, if you did a SWOT analysis, right, what would you say are the absolute priorities for incentivisation and just transition or actual support from government?
There's a lot there to unpack, Patsy. So I'll start with the financial, social, economic impact assessment. So in terms of those short-term costs, those short-term costs, I suppose we're thinking about within the span of the climate action plan. So investing in measures to be more efficient within our homes, or purchasing an electric vehicle, that incurs an upfront cost. But ultimately, there are savings to be made in terms of being more energy efficiency. So that's the long-term savings that the FSEIA is referring to. In terms of the rural needs impact assessment and transport, I suppose it's DFI could give more detail about this. But through the climate action plan, there's opportunity to address some of those issues. So one of the actions within the transport sector is about switching to electric vehicles, about providing opportunity for alternative forms of transport, walking, cycling, public transport as well. So there's an opportunity there to address some of the issues that rural communities face.
Sorry to interrupt you, but if you're living in a rural area such as mine, walking to your doctor isn't an option, nor is cycling to your doctor, especially if that person has quite a lot of health issues, which does bring me on to another point I would like to throw into the mix, please, and that is, there is, and I read some of it last night, changes been proposed to the welfare system. Now, that as of itself will deprive people of income. There's no doubt about it. I've looked through it. Especially those who are on PIP and the consequential passport benefits for that, that's going to reduce income. Now, it's going to reduce income across the board, but if we take that to a rural area, right, that person's income will nosedive through no fault of their own. They have ill health, they have problems and difficulties. So what I'm trying to look at is contextualise that in a rural needs impact assessment. Those people aren't going to be able to afford an electric car, full stop. If services are being denuded, stripped of our rural areas, whether it's access to go to school, to a doctor, GP, hospital, whatever, this is fine in theory, which is grand, but who's going to pick up the pieces to make sure that our society isn't, especially those most vulnerable, aren't worse off?
Patsy, the climate action plan isn't about imposing actions on anybody. So someone with health issues isn't being asked to purchase an electric vehicle. So what it is doing is encouraging that transition to lower carbon alternatives where that's feasible, and that's what the climate action plan is doing. So the Just Transition Principle as well aims to protect people who are vulnerable, and that's to ensure that those who are affected in that way are supported in doing so. And within the Climate Action Plan, there are measures that would provide that support through schemes to people who do need it.
It is just, thank you for that, but it is a just transition principle. It's the practice and the outworkings of this that I'm concerned about, because that's why it's called just transition, to make sure that people don't drop off or aren't dropped off the edge in society. So, but I look forward to more proposals. And the issue that I asked then about the SWOT analysis, if you're doing a SWOT analysis, what would your priority concerns be?
Priority concerns in terms of?
Of what would you say, these are actions, what would I prioritise?
I think for the purposes of the Climate Action Plan, in order to meet our legislative targets, we're saying that all of those actions are required. So taken together, all of the policies and proposals that are set out and contained within the Climate Action Plan are needed to hit that statutory targets, that carbon budget of 33%. That's what we're needing. So it's all of them together rather than one being more than the other.
Okay, right. Thank you. Thanks, Chair.
Maybe I could just say, just from a numbers perspective and the quantification, this the focus is on 2023 to 2027 and getting on the right trajectory. But there is a recognition that there will be a need for new policies, proposals to come in for the second and subsequent carbon budgets, and just monitoring and reviewing evaluation of the first carbon budget to inform the subsequent carbon budgets are really, really important, because the average 33% is based on getting to around 37% reductions by 2027. And that's seen to be the minimum reduction to be on the right trajectory for 48% by 2030. But this is a long journey, and the key issue has been on the pathway, but recognising, from the quantification exercise that we've done that specific to this first carbon budget, but knowing that there will be a need for future policy development across all sectors for the second and subsequent budgets.
Picking up, I suppose, on the sort of policy choices piece, one of the things that we did do is we took it's over 50 policies and proposals that are in the Climate Action Plan, and we did look at a range of scenarios. So the 33.1% that we discussed at the start, which is the projected sort of central expected outcome of the draft Climate Action Plan. We also looked at more optimistic tailwinds scenarios. So if some policies progress quicker than we'd expected, and we'd also looked at what we call a headwind scenario if some things don't happen as quickly. And so there is within the set out sort of in the annexes to the draft cap is what those different scenarios would achieve. So we do absolutely understand that there is a range of potential outcomes here across all of those policies, but we've then tried to hone in sort of defining a number so that we can accurately assess if what we have in the draft cap is enough. We have focused then on that sort of expected outcome.
Okay, thank you.
Thomas.
Thank you, Chair, and thank you folks for being here today. Your capital investment programme on the agriculture pillar of CAP is classed as unsubstantiated, and there's no detail provided as how this would be delivered. Can you give us some indication today as how this programme will be delivered?
Well, one work stream that's currently under development, I think it's due to launch later this year or early 2026, is the investment capital investment package measure. And as I mentioned earlier, it will include a wide range of on-farm investments that farmers will be supported through with grant aid to adopt. As I mentioned earlier, improved handling systems, for instance, to aid that management, to improve the productivity of their livestock, etc. And a wide range of other capital investment measures that will help farmers to improve their sustainability across the piece.
Yeah, and when will that be coming on stream? Because there is no indication of it within your document.
I would need to check the detail of that, but I think it's either late 2025 or early 2026.
Yeah. I suppose one other issue, the research cited under the proposals around biomethane assumes a 50% increase in slurry irrigation systems in dairy and beef and pig sectors. Is this feasible? And what consultation has there been with the Ulster Farmers Union on this? Are they of the same mind as what you folk are on this particular issue?
Well, if you look back some considerable years in terms of some of the issues we had with fatalities around mixing slurry, etc. At that stage, there was a lot of involvement with the farmers' representatives, with the health and safety executive, looking at safer ways of mixing slurry. And one system that the HSE would have recommended as a result of that work was aeration. Now, in terms of a 50% increase in aeration, we'll be starting off from a very low base in terms of the data that we've been able to obtain from industry, somewhere around about 1 to 3% of slurry aerated. But that is just one aspect of those slurry treatment technologies that we're looking at. There's other very exciting technologies too that would be much more retrofittable than aeration to treat slurry to reduce all of the associated gases coming from the slurry in terms of the methane, the ammonia emissions, and also from a safety point of view, the hydrogen sulfide emissions. So there's a lot of developments taking place in that space.
How are you engaging with Ulster Farmers Union in around all of this issue?
Well, in terms of the agriculture sector CAP development and the modelling associated with it, I personally have presented the ongoing work on 5 occasions since 2021 to the Dairy Agricultural Policy Stakeholder Group. So at each stage of new pieces of work carried out or access to new data that we obtained, for instance, from the Climate Change Committee as far as modelling for the Northern Ireland Devolved Administration for the UK 6th Carbon Budget, we presented that data as we got it available. Then the first of 3 stages of development of modelling for the agriculture CAP using the ADAS scenario modelling tool that we've got access to. That data was presented on 3 different occasions at each step in the process, the most recent one being after the development of the range of scenarios for the CAP in terms of the, as Paddy has referred to, the headwinds, the central and the tailwind scenarios. So there's been quite a lot of engagement with representatives of farmers through the Agricultural Policy Stakeholder Group.
Thank you, Chair.
Thank you, Tom. Okay, members, are we content at this stage? Yeah. Thank you so much for your presentation and for taking so many questions. I'm sure we'll talk again. Thank you.
Thank you.
Thank you. Okay, members, we're now moving on to agenda item 9. And that is the SL1, the Environmental Protection Single-Use Vapes Amendment Regulations, Northern Ireland 2025. Members, on your packs at page 1262 to 1273, the draft SR and the explanatory memorandum are there. You will recall that the community previously approved the Environmental Protection Single-Use Vape Regulations, Northern Ireland 2024, which bans the sale and supply of single-use vapes in Northern Ireland, which came into operation on the 1st of June 2025. Several areas have been identified where the 2024 principal regulations could be strengthened to safeguard against illegal single-use vapes re-entering the marketplace. The Department intends to make this SR to provide with additional enforcement powers to ensure the ban on single-use vapes is applied equitably in Northern Ireland. I now welcome the officials to meet and invite them to brief the committee when they get comfortable. So we have Mr. Carl Beattie, Deputy Director, we have Mr. Tommy McNamara, the Policy Lead, and we have Mr. Sean McVeigh, a Policy Official. And we would invite you to brief the committee, and the members do have their papers. Thank you very much.
Thank you, Chair. Tommy and Sean are our subject experts on this, so Tommy's going to give an opening statement, and then we'll be happy to take any questions you might have.
Thank you.
Morning, Chair. Morning, all.
Afternoon.
behind the times myself here. Sorry about that. Good morning. I said good morning because I thought we were getting done in the morning, so apologies for that. So I want to thank you for the opportunity to brief you on the Environmental Protection Single-Use Vapes Amendment Regulations 2025. So in November 2024, the committee previously approved the Environmental Protection Single-Use Vapes Regulations 2024, which banned the sale and supply of single-use vapes in Northern Ireland from 1st of June 2025, which aligned with legislation brought forward by the other UK governments and ensured a UK-wide ban on the sale and supply of single-use vapes. There are three main policy objectives that underpin the proposed statutory rule. These are, firstly, to strengthen the enforcement of the ban on sale and supply of single-use vapes. Secondly, to safeguard against illegal single-use vapes re-entering the marketplace. And thirdly, to ensure the ban on the sale and supply of single-use vapes can be enforced equitably in Northern Ireland. Unfortunately, the primary legislation under which these regulations and the 2024 regulations are made does not provide power for enforcement officials to seize illegal vapes. These proposed amendments will provide for the Department to direct that illegal vapes are to be treated as waste and disposed of or otherwise treated as the Department considers necessary. This will ensure that illegal single-use vapes will be disposed of correctly and cannot re-enter the marketplace. The regulations also will make it an offence not to comply with the direction of the Department. In addition, at present, for the purpose of enforcing the ban, the term bodies corporate applies only to companies. It's proposed to expand the term to include both partnerships and unincorporated associations, which will ensure that enforcement will be equitable throughout Northern Ireland. The inclusion of partnerships is particularly relevant as there are a significant number of family-owned retail businesses in Northern Ireland. The proposed amendment will also ensure that enforcement provisions broadly align with similar provisions currently enforced throughout the rest of the UK. There is no statutory duty to consult on these regulations. However, DERA was required to publish the draft regulations in the Belfast Gazette for a minimum period of 2 weeks. No responses were received following publication of the draft regulations. You may wish to note, however, that public responses from the previous consultation to address smoking and youth vaping were strongly in favour of a proposal to introduce a prohibition on the sale and supply of disposable vaping products. DERA officials continue to engage with local council representatives on how the single-use vapes ban can be effectively enforced. Councils have expressed concerns with regards to resourcing requirements, however. We have also reached out to the Public Health Agency, who fund tobacco enforcement in local councils, to discuss the possibility of using tobacco control officers for this purpose. Executive approval to introduce this legislation to tackle the environmental impact of single-use vapes by means of a ban was secured on the 3rd of April 2025, and we have laid the draft regulations before you today in keeping with our commitments. Unfortunately, due to legal complexities, it was not possible for the statutory rule to align with the coming into force date of the ban on the 1st of June. However, once laid, the intention is for the regulations to come into force 21 days after being laid at the Assembly. I'm happy to take any questions you may have.
Okay, thank you very much. So the legislation that we did bring through really took effect from the 1st of June, I think, of this year. So we have no measurable quantification yet of the effectiveness of this, but this obviously seeks to rubber stamp and enforce a part that was missing. Have those, in terms of the other devolved legislatures, was this an additional piece that had to be brought to Wales and Scotland and Westminster? Was it missed in that primary piece then?
They had it contained in their primary piece.
Okay.
Because I think the rationale for us not including it at the time is we didn't have a functioning executive at the time when they started all theirs, so we were behind schedule in getting our legislation progressed, and this is an enforcement mechanism that's never been used in Northern Ireland previously, so the decision was taken to progress, make sure the ban aligned on the 1st of June, and we would try to catch up with this later on.
Okay, and I think you're quite clearly stated that this will take effect 21 days after it's laid. It doesn't need further assent. It doesn't have to sit in a stovepipe. This is
no. It's negative resolution.
Negative resolution. Yeah.
Negative resolution.
Okay. And could you explain to us or define for us? Will this put an onus on councils, particularly to dispose of seized vapes? How is that going to be mechanised?
No, it won't. We're still engaging with councils, but the direction that we hope to bring forward. We're still liaising with the Department Solicitor on the actual wording on the direction, but what we hope to do is to put the emphasis on the holder of the single-use vapes to dispose of them. So the direction will say that all vapes are to be deemed as waste, and that the holder must dispose of them in accordance with best practice. It's through Regulation 31 of what they call the Waste Electrical and Electronic Equipment Regulations. So the onus and the costs incurred of disposal will be on the holder of the single-use vapes.
And how is that? How do they dispose of them then?
You have to take them to a licensed waste contractor, and it will be within the direction it will say that you will have to provide evidence of that to the department upon request.
Do we have licensed waste contractors capable and have the capacity to do this? And
there are licensed waste contractors, yes. They won't be able to recycle them in Northern Ireland. I don't think we have enough recycling facilities, but they will be able to. Normally what happens is they are taken over to GB to be recycled.
I'm just thinking the logistics of this, how it sort of appears to me that the prevalence of single-use vapes will be particularly young people. How do we encourage, how do we inform, and how do we encourage, and how do we enforce that this happens?
Well, this is aimed primarily at the retailers of single-use. So this will only apply to single-use vapes that are offered for sale or supply. It's not aimed at individuals. Individuals are. There's a different set of regulations, which are those waste electrical regulations, and retailers who sell any type of vapes are already required under law to provide a receptacle for you to bring them back. They're required to take them back. So that is already in law, and that is already operational. This particular direction is aimed only at the retailer. So the holder, as in holding for sale or supply, not the individual use.
Thank you so much. Any questions, members? Declan?
Just a brief question. I note that under the financial implications that there will be some additional costs associated with enforcement of the ban. Will that be on local councils? Has that been quantified in any way, or?
It hasn't been quantified. There's a potential for additional costs, is I think what we have said. It hasn't been quantified. We've been engaging with councils, and we have asked them, when they have expressed concerns that they have in relation to resource requirements, we have requested them to supply. I suppose it would be estimates, of course, it's not going to be details, estimates of where they see that those costs would lie. And once we get that information, we can look into that further.
And have you had engagement with Solace or Nilga or any of those umbrella?
We have engaged with Solace, yes. We requested a meeting a number of times. To date, there's actually only been one meeting our director was able to obtain with the chair of Solace. But I think I know he's pushing for another meeting in the not too distant future.
I note from the briefing paper that the South of Ireland is going in the same direction. They're just behind us. Will that undermine us, I suppose, if you're living in the border region, that if people would be travelling north south, that they're two different.
There's always the potential for that. We are at an official level, we remain in contact with our counterparts in the Republic of Ireland, and the Minister has also written and asked for an update from Minister Carol McNeill, who has said that they are progressing it and they will be pushing ahead. And she reaffirmed her commitment to Minister Muir that they will be progressing the ban on single-use vapes. We don't have a timeline as yet because apparently it's still the drafting of the bill is still with the Attorney General.
Just come back. I won't go back to the councils for a second. So will that be at one point? Will you be able to bottom out effectively what the potential cost might be to councils for implementing this?
Unfortunately, we need the council to provide those figures because it's the one thing we don't have is the data relating to councils as to how much it will actually cost them. So we have asked them to provide just to provide an estimate of what they essentially think the cost will be, and then once they do that, we can progress it further, discuss things further with them.
Ultimately, in the legislation, the enforcing authority is the department, but the councils can be authorised, and that's essentially what this piece of legislation does, and we see that there are certain synergies in the councils carrying out this enforcement, but obviously there is a potential cost, and but we consider the cost is likely to be significantly higher if the department is carrying out enforcement. So we need to, as you say, bottom out those figures and determine the way forward.
Yeah, thank you. Thank you, Chair.
Thank you. Any other members? Patsy, you'd indicated, yeah?
Very brief one. You say here, well, reading from the briefing, the preliminary briefing document, to ensure that the enforcement regime for Northern Ireland is both robust and equitable. In practice, what does that mean?
Well, the robust is to make sure that the single-use vapes that are detected and found can't re-enter the marketplace. Because as the regulations currently stand, all that can happen is if someone is found selling single-use vapes, they can be prosecuted. But we can't demand that they dispose of the single-use vapes. Effectively, we have no control over what happens to those. So this will make it a lot more robust, and that the direction will demand that they get rid of them in respect, through a licensed waste contractor. There's control there, and that's what makes them robust. The equitable argument comes down to the fact that if someone in a supermarket is selling cigarettes, one of the big supermarket giants, well, not only can they be prosecuted, but also the supermarket giant can be prosecuted as what's called a body corporate. But that doesn't apply if a person in a family-owned retail store that's a partnership, or who works in a club, sells it. Only the person who sells it can be prosecuted, not whoever holds chairmanship of the club or is a partnership in a business. So it makes them also, so that's the equitable part of it.
So from what you've explained to me, there's going to be a whole lot of checking to be done.
It's not that there's a whole lot of checking to be done, rather this just makes sure that the responsibility, extending it to partnerships and unincorporated associations, which is the legal term, just means that the ultimate responsibility for the marketing of the vapes and the prosecution can be taken against who owns or who is responsible for those, not just the employee who is actually selling the vapes.
I get that, but somebody's going to have to check to make
Somebody
sure.
will have to check, yes.
And that's where you're going to have to delegate, or whatever it is, authority to the local councils, which brings me back to Declan's point. That's going to rest then with the local councils and whatever additional resource, if any, they can provide to do this. So I think it would be interesting to hear just from Solace how they view this, if there's any comms or communication or reaction to these proposals from Solace. I think that would be important, Chair. Do we hear that? Because we could talk all day here about single-use vapes, but if it's impracticable to be enforced, it's
Yeah, just to close that point out, if that's okay. If members are content, we'll write to Solace from the department just off the back of that, just to give clarity. Are there any other questions from members? I've just got one. It says here in terms of the consultation, you could just give me a bit of clarity around this, because it's the first time I've seen it. There's a requirement for DAERA to publish the draft regulations in the Belfast Gazette, which is slightly different to most formal public indications, although in a quick look it looks like the Public Gazette might not be a publicly accessible publication, or it may be. Could you give me some sort of detail around, is there a nuance to that?
Usually not for a different reason.
It's not a nuance, it's actually required under the primary legislation, which is the Waste and Contaminated Land Order. And it is a legal requirement within the primary legislation that any draft regulations made under that have to be published in the Belfast Gazette.
Okay.
So, but there's no formal duty, obviously, under that primary legislation to do a formal consultation.
Every day is a school day. It's always good to learn, stay humble, which I have to be fair. Thank you so much. Really appreciate your time today. Thank you. Thank you. Okay, members, so we've agreed we're going to, in terms of Patsy's and Declan's point, contact Solace to get an update from them in that regard, okay? So members, are you agreed that the department proceeds to make the ESR and we will then consider it and the ESR report in due course? Yep. Thank you. Thank you. Thank you very much, members. Okay, agenda item 10 is the eel fishing amendment regulations. I refer you to pages 1274 to 1281 of the pack for the SL1 letter, the draft SR and explanatory memorandum. You will recall that we were briefed by the Lough Neagh Fishermen's Cooperative Society Limited at our meeting on the 22nd of May, when we heard of the importance of updating the eel management plan and that the high quality European eels in the loch have deteriorated due to a combination of factors, including the issue of separate mussels, poor water quality and the collapse of the fly population. This has led to the suspension of commercial eel fishing, which could lead to the loss of important markets. The Department intends to make this SR to promote more sustainable management of the Loch Ness eel fishery through 3 measures. It's the revision of existing fishing seasons, providing a mechanism for DAERA to set catch limits on the brown and silver eel fisheries and setting a maximum catch length. It will be led before the Assembly under negative resolution procedure. So I'm now going to welcome the following officials to the meeting and invite them to brief the committee. Mr. Colin Armstrong, the Deputy Director of Legislation, Ms. Kelly Mills, Deputy Director of Regulation Enforcement, Mr. Seamus Connor, Chief Fisheries Officer, Mr. Roy Griffin, Inland Fisheries Policy Division. We've got 3.
Good afternoon.
Yes, good afternoon. Yes, I think as Kelly not joining us. Not a bother. Thank you very much. So we have it papers, but if you'd like to brief the committee, then we'll move to questions, if that's okay.
Okay, thank you.
Thank you.
Well, firstly, thank you for the opportunity to present this proposal on the amendment to the eel fishing regulations 2010. I want to note first off that the fishery is of ongoing historic importance to Northern Ireland and is of significant economic benefit to the fishermen and the rural communities around the loch. The eel fisheries worked hard for years to secure PGI status and develop and maintain this status and their markets. And I just wanted to start by recognising the effort that's gone into the eel fisheries put forward into protecting their own fishery. Right? The measures within this regulation we consider are vital for the protection of the fishery going forward. It's been proposed as a means to support compliance predominantly with the eel management plan. This is the eel management plan for the Nay River Basin. We have to note as well the fisheries and this is a fishery on what's classified as an endangered species. The Loch Ness Eel Management Plan is the means to demonstrate that the long-term sustainable potential is the means to determine the long-term sustainable potential of the fishery. It was developed on the principle that the commercial operation of a fishery is not only possible but actually is of wider benefit to the stock. It actually supports the regrowth of the wider population or the rebuilding of the wider population. However, this is only true while the terms of the eel management plan are being met. Okay. Under the eel management plan, the commercial fishery undertakes a level of restocking, which provides for commercial catch and escape to the wider river system and ultimately to the sea. The life cycle of the eel means that the benefits of restocking today may not be seen for between 12 and 18 years. So we can see this. We can see the effects of restocking coming through the system, and the need for action was highlighted as early as 2019 to the Loch Ness Fishermen's Cooperative Society, when it was recognised that there would be a decrease due to the level of historic level of stocking. As the cooperative informed this committee previously, the reference level for restocking within the eel management plan has only actually been achieved once since 1988. That is a concern, but I also note that there has been ongoing issues with obtaining stock for the fishery, and that has influenced how successful it's been in the last few years. So since 2021, the situation has deteriorated further with increased concerns over the level of the catch and the escape level. The value of the eel fishery was once over £3 million a year. In the last few years, it's struggled to reach £1 million, and this is just a reflection of the level of falling catches. The escape level, which is the key measure within the eel management plan, has not been met now since 2021. This is the 3-year rolling average, where the 3-year rolling average has been below the 200-point trigger, which requires action to reduce the exploitation of the species. The plan also recognises the role for the department to implement additional controls, and we feel this is now necessary, and hence our proposal. A bit on process. We sought scientific advice for possible measures to address our concerns. These were presented and discussed with the cooperative in January 2024, and this has led to the proposals we see today. There has been ongoing engagement on this issue, including detailed discussions led by the Minister, with the outcome that the cooperative agreed to the measures and the need to take action. Throughout the course of this engagement, the cooperative have raised a number of concerns over the implications that would have for their business and the future of the eel fishery, and we've tried to address these as we've progressed. The Ministers also met with the cooperative on a number of occasions and provided a number of reassurances throughout the process. For example, the regulation will not be applied until January 26, and there's a clear process set out for how our catch limits or lengths are going to be set, which ensures that the cooperative are fully engaged in the process and will be supported by the best scientific advice. The Minister most recently met with the cooperative on the 13th of June, and I just wanted to inform you that he discussed possible financial support and sought to address some of the cooperative's concerns over changes to the assessment and analysis of the two silver and brown eel fisheries. I'd just like to say as well, the information that's been developed by AFBI and with the support of the cooperative is one of the best data sets going. And it's one of the best issues in the eel assessment, and there's no intention from the department to reduce that. We want to see the data collection maintained and supported. Right, so the most immediate risk from not meeting the requirements of the eel management plan is the loss of trade from Northern Ireland to GB. Currently, eels as endangered species require the CITES permit to allow trade to GB. These are issued by DEFRA under non-detriment finding. The non-detriment finding requires demonstration that the fishery is sustainable. It's a live document, it can be amended any time, but there is a formal review due next year in 2026. I should note this is done by an external contractor, not the department itself. So we need to make sure that we can demonstrate that the fishery is either sustainable or that we've taken remedial action to try and make it sustainable. In the longer term, the UK publishes reports every 3 years on the performance of eel management plans. In the last one, in 2023, they noted the difficulties with meeting the compliance targets, and there was an indication that some remedial action will be taken. In the longer term, we need to make sure that we deliver on that and to take actions to address this loss. Otherwise, we could run into a longer term failure of the fishery. So, in summary, I'll be quick. We're proposing this regulation to support and protect the long-term future of the eel fishery. The measures, as discussed and agreed with the cooperative, are the revision of the 2 fishing seasons, setting of catch limits for the brown eel fishery and the silver eel fishery, and having the power to set a maximum catch length to protect large females. These measures will not come into effect until the 2026 fishery season. Thank you.
Thank you. Good. Okay. So I know this will be picked up when it's been tidied up, but there's just a bit of a typo on clause 2 in the clause 2, subsection 2, and when it comes to annual catch, it talks about bottom paragraph there. Says means eels of AA specific length. It's just a minor one. I just looked at it to clarify to see if it was. But it actually drew me to actually look at that a wee bit more detailed. I'm interested in this. So the maximum landing size for eels is to do with the snout to tail of the fish. But in terms of the regulations, it says a person should not willfully fish for, take, retain or kill an eel in excess of the maximum size. But there's no reference to minimum size, or is there?
There is a minimum size.
Okay.
For eels, it's set is 40 centimetres.
It's set, but the maximum size is annually adjusted.
Yeah.
Based on. Okay. No, I get that. Thank you for that. It was actually an interesting point to pick out. So last week we received correspondence from the Lough Neagh Fishermen's Cooperative. And we had a number of weeks ago a session with them that was excellent. It was one of the best sessions we've had. And they've raised a number of concerns, but one that they've raised with us is that given the importance of understanding the number of eels, this season's planned and agreed sampling schedule is to be reduced, so there will be more reliance on retrospective data, is what has been said. So have you got a rationale to explain why that would be the case this year?
Yes, listen, I'm happy to pick that up. I should say, look, from the outset that in terms of the data required, both for the CITES NDF, there's a non-detriment finding, and in terms of ICES, that we are fully meeting our requirements under that there. In fact, we are, as Roy mentioned, we're one of the few companies that actually provides all the data that's required for ICES. So this arises in terms of us sampling the fish, and it's more about the analysis of the catch. So for example, we look at the analysis of catch, which has remained fairly static over the last number of years. There's two methods to catch. So they can use a draft net or they can use a long line. And depending on the bait then, it attracts maybe more juvenile eels than different types of bait, and also in terms of the composition of the sample itself. So we have decades of data there, and I say nothing in that has actually changed. So because they had a particular issue about the anaesthetic we were using, so there are very limited options on the anaesthetic that we can use. Clove oil is particularly effective on eels. It's also authorised by the likes of the Food Standards Agency. There is no withdrawal period for it. Some of the other chemicals are not as effective, and also there'll be a number of days of withdrawal period. So we had a full review. AFBI reviewed entirely their data set and came to the conclusion that really we don't need to carry on with as much sampling as we do. We still meet the requirements, which is the key bit of it around that stock analysis, what's there, what's coming in terms of juveniles, and in terms of what's escaping, which is probably the critical one. So we're fully met. So I have no issues in terms of the changes to it. I know there might be a perception that somehow we're stepping back. I should also indicate that the department has an evidence and innovation project on Lough Neagh currently, looking at some of the wider issues that may impact on eels, such as zebra mussels and some of the food that they're using as well. And we also are providing funding for a new PhD students to start this year, looking at those broadhead eels. So the co-op maybe mentioned these kind of broadhead eels were assigned there, so they're going to look at those both in Lough Neagh and Lough Erne. So that's a new PhD student that will be focused specifically on some of those issues there. So I can assure the committee that, look, we have no issues around there.
On a position of confidence as opposed to... Okay.
Yeah, it might be a perception that we're somehow stepping back in, but look, we have decades of data. You know, we've often referred to Lough Neagh as being data rich, and we have, you know, a huge amount of data there, not only from the fishery itself, which is unique actually in many respects, but also in terms of science. You know, we're one of the few people that actually provides all the requirements for ICES currently.
That's a fascinating piece, I have to say. It's really interesting. Declan?
No, he doesn't.
No, Patsy? Sorry.
Just one thing, to get it clear, the Lough Neagh Fishermen's Cooperative have bought into this, so they've been consulted. They're in agreement with the way forward, yes?
Yes.
Aye. Okay. That's grand. Thanks, Chair.
Okay. Okay. No, okay, that was brief. We're content. Thank you very much for your presentation. Appreciate it. Thank you. Good night. Okay, members. I agree that the department then proceeds to make the SR, and we will then consider it and the SR report in due course. Yep. Thank you. Thank you. Okay. Agenda item 11 is the SR 2025-103, the Horticulture Pilot Scheme Regulations. Members are referred to pages 1283 to 1294 of the pack for the SL5 letter S and the SR and explanatory memorandum. Received a briefing on the SL1 at our meeting on the 5th of June and heard that the department intends to make this SR to provide with legal powers to implement the horticulture pilot scheme as part of the rollout of the Sustainable Agriculture Programme. We also heard about the overarching aim of the scheme to determine the feasibility of a full horticulture scheme to increase the output of Northern Ireland commercial horticulture industry. The department states there's been no change to the SR since the SL1 submitted to the committee. The SR will be led before the Assembly under the negative resolution procedure and is subject to executive approval. It's anticipated it will come into operation on the 26th of June, which is hard to believe is next week. We agreed that the department proceed to make the SR, so I will now put the question on the SR. That the Committee for Agriculture, Environment and Rural Affairs has considered SR 2025-103, the Horticulture Pilot Scheme Regulations 2025, and there's no objection to the rules subject to the report of the Examiner of Statutory Rules. Are you agreed? Thank you, members. Okay, agenda item 12 then is correspondence. So members are referred to pages 1296 of the pack, the correspondence from ARC regarding two of its recent publications, which start at page 1297 of the pack, and that is the attitudes to climate change in Northern Ireland and ethnic diversity and environmental leadership in Northern Ireland. Are there any comments you content to note? Content to note, thank you. Members, I refer you to email correspondence from an individual dated the 12th of June, page 1311 of the pack, regarding the Craigmore Road, Garva landfill site. The individual states that there's been low-level air pollution release on several occasions on the site. We obviously referred to this earlier on in the committee meeting with regard to the sniff test employed by DAERA. Are you content to note any comments to make in this regard in this one? It's just building up to the portfolio.
Are there issues there for NIEA?
Well, we've little detail. I think that's the first correspondence we've received in regard to that location. But I mean, we can ask. We could ask.
I think it'd be helpful.
Has there been any indication that there has been any action taken? Yep. I think it would help us build that portfolio. Members 12.3 members are referred to page 161 of the table papers to correspondence from the Department to the 17th of June regarding the launch of a citizen space survey to establish a baseline level of public understanding and awareness of air quality. The citizen space survey will run from the 16th of June for a period of 8 weeks. If you have any comments, you can tend to note. Thank you, members. Agenda item 13 is the forward work programme. A draft forward work programme, you can find your table papers at page 164. Do you agree that the forward work plan is published? Yep. Members, does anyone have any other business? Date, time, place of next meeting. Our next meeting is on Thursday, 26th of June at Parliament Building, starting at 10 a.m. and the meeting is now adjourned.
Committee Room 21. Sound.